Welcome to the Fourth Circuit. We're happy to hear from counsel on our first case, 24-1324, Alvarez-Ronquillo versus Bondi.
Good morning, Your Honors. May it please the Court, John Pang with Georgetown University Law Center's Appellate Litigation Clinic. With the permission of the Court, third-year law student Angeline Superable will present arguments on behalf of Petitioner Genevieve Alvarez-Ronquillo.
Thank you very much, counsel. Happy to hear from you. Happy to hear from you, counsel.
Thank you, Your Honor. Good morning, and may it please the Court. Mr. Alvarez-Ronquillo, a lawful permanent resident of this country for 38 years, is not removable because his conviction for the unlicensed sale of firearms under 18 U.S.C. Section 922 A1A is categorically broader than illicit trafficking in firearms. Mr. Alvarez-Ronquillo was convicted under Section 922 for selling firearms without a license. By its plain text, a seller could be convicted under 922 for selling outside of the scope of one's license. Under 922, it makes no difference who that buyer was. Whether the buyer was a police officer or a felon, if the seller lacked a license at the time of the sale, the conviction stands. Compared to 922's broad sweep, the INA's trafficking in firearms is more narrow. It requires the deliberate transfer of a firearm to someone barred from owning one. It's one thing to sell without a license. It's another thing entirely to know that someone can't legally own, carry, or possess a gun and still hand it to them. Without a categorical match between his unlicensed dealing conviction and the trafficking in firearms removal ground, Mr. Alvarez-Ronquillo is not removable. Congress gave us its definition of trafficking in firearms in Section 933. In fact, it is the only definition of trafficking.
When did they do 933?
2022.
Okay. And we're trying to understand what the words were used in 1989?
1988.
88. Why would we look? I understand that sometimes we look at related subsequent enactments, but that seems like a particularly odd place to look for a definition. It doesn't actually define the word anyway, but it seems particularly odd to look at the definition or look to a statute to imply a definition, which I think is what you're really saying, from 30 years later. Why should we consider that?
Your Honor, it's the only piece of evidence we have from Congress confirming what it means when it says trafficking in firearms.
So why do you think it needs to be from Congress, right? Don't we sort of typically say, the Supreme Court tells us over and over again, we look at the ordinary understanding of the words, right? This isn't some Congress-specific story, right? It seems like to me all the time we look at sort of the ordinary understanding of words, and there are lots of ways to understand that, and dictionaries are one. You've pointed out a number of the problems with dictionaries that are well documented. But typically we look at the time of the enactment. And so we might look at something and sort of try to understand what the word trafficking means. We use corpus linguistics. We do a comparison to how that language is used at the time. We don't typically look 30 years later and then try to imply by negative implication, which is what you're saying, when they define one type of trafficking, that's the only type of trafficking, to understand what it means.
We believe that when we look at two contemporaneous sources from the time of the enactment of trafficking in firearms in the INA, that dictionaries fall short. And so we try to reckon with this, as the Supreme Court did in Esquivel-Quintana, looking at other sources that we can glean Congress's purpose and intent and really confirm what they meant at the time of its enactment. So that's what we think 933 is. It's a definition that confirms what Congress meant.
Did the Supreme Court look at something that was 30 years later and imply a negative inference from it? Like, that doesn't seem like what the Supreme Court did at all.
That's correct, Your Honor, but it did look to, as you mentioned, a closely related federal statute, and we think that the phrase trafficking in firearms only being defined there in 933 is good evidence and persuasive evidence for finding that trafficking in firearms entails the deliberate transfer of a firearm to an unlawful recipient.
So what's wrong with the BIA's interpretation, the ordinary meaning that they apply? What's wrong with that?
The board's interpretation relies on a series of cases and decisions that it put forth, specifically Matter of Davis, to understand what trafficking meant in the controlled substances context. We think that controlled substances and firearms are distinguishable. We see that in the nature of the objects themselves. For controlled substances are inherently contraband. They're already illegal by nature.
But is that true? Because I don't actually think that is true, right? I mean, I can possess heroin if I have a license to possess heroin. Now, admittedly, it's really hard to get a license to possess heroin, and unless I'm like a medical research company, I probably will not get a license. But it's not inherently illegal to possess heroin. It's illegal to possess heroin without an authorization from the FDA.
That's exactly right, and I should clarify that it generally is illegal to have contraband, in this case controlled substances, as a general person. But for firearms, it's generally legal to own or possess or carry a gun so long as...
How much work is generally doing there? Because I took Judge Hyten's question to say, just like with firearms, there is legal dealing in controlled substances, right? Take oxycodone, right? Like the heroin example is one, but like oxycodone's another one, right? That it is a controlled substance. If you sell it without the proper authorization, then it's illicit trafficking, right? So like a pharmacist who is selling it out of the back of his store, right? He's not doing it in accord with his license, and so that's trafficking in oxycodone in the same way that, you know, a gun shop, an FFL, who might properly use the forms and do everything at the front of the store, if they're selling it out of the back without the right paperwork or the like, that's trafficking in firearms. I guess I'm not sure I understand the distinction. It is true that trafficking, it goes both ways, right? Both on the upstream, are you authorized to do this? And on the downstream, are you giving it to someone who is then authorized? But I don't see a distinction between the two. Help me understand why that is.
I think what I'm focusing on is the ownership or the possession or the carrying of that object, controlled substances versus firearms.
But if I've got a prescription for oxy, right, then I can have it.
Right.
Right? So like if my doctor's prescribed oxycodone to me because I have a bad back, like I'm entitled to possess it. If I don't have that prescription, I'm not entitled to possess it. Right? That seems like the same downstream concern that we've got with firearms.
But we see across the United States, you don't need a permit to own a gun. A father can give his daughter a gun in the safety of their own home, and that daughter can use that gun or have that gun legally without any sort of authorization.
That's just an opposite default, right? So in the oxy context, I need an affirmative authorization. In the firearms context, it's just the absence of a negative authorization, right? But like that, I don't understand why the default makes a difference here, right? They're a group of people that are permitted to have oxy, and they're a group of people that are not. If you sell the drugs to somebody who's not permitted, that's bad and it's trafficking. Same thing with guns.
I think that's right, Your Honor, but 922 goes broader than that. 922 specifically, one can be convicted under 922 for selling outside of the scope of one's license. So an individual could own a storefront, be selling guns out of that storefront for years, make a sale from their home outside of their storefront, and be convicted. So finding that
And the same thing, right, for a pharmacist, right? So the pharmacist that sells out the front of his store, I mean, this is the example I just gave, right? So yeah, I mean, I understand you might think that that's different, but I don't see how it's different between narcotics or controlled substances and firearms. That's the rub I'm not seeing. To me, those seem like exactly analogous scenarios, right? There's upstream, some people are authorized by law to do this in certain ways, And there's downstream. Some people are authorized to receive them or possess them, and others are not.
I think for the trafficking in firearms conviction, you're really hitting on a point of where is that going? And that's what our definition from 933 points attention to. We look at the nature of the recipient. Are they unlawful? Are they authorized to have a gun, or are they not authorized? And so we see in trafficking in firearms something more than just a regulatory or licensing offense, something more focused on the proliferation of criminal networks or something more.
So if I took 933 on its face and thought it was relevant for some reason, why would I take that negative implication? So 933 says this is trafficking in firearms. It includes selling to people who are prohibited, right? I mean, that's what 933 says. But why do I infer from that that trafficking in firearms does not include what you call a licensing issue, right? The fact that 933 includes one type of trafficking, why would I infer that trafficking in firearms does not include the other type of trafficking that we would naturally think of, which is the pharmacist dealing out of his house, or the FFL selling, in the alleyway behind the store?
I believe that we do not see it as the same thing because.
Yeah, but why?
Because of the nature of that transaction. Sure, it could be someone who is nefariously intending to sell things, sell guns outside of their storefront and get them to the wrong people, but it could also be an innocent person who's just trying to make a sale and who has complied with the government on its regulations, getting that license, getting license for their storefront, et cetera, having that for several years, renewing it, and then conducting a sale out of their home. They would be liable for a 922 offense. I think that doesn't respectfully look like trafficking in firearms.
Could I ask you a different question about your
Sure.
933 argument? So one of the arguments I see in your brief is that interpreting the statute a different way would render 933, you said, I think, largely redundant, is the words you used in your brief?
Mm-hmm.
Can I just, why, in the following, here's the question. Can an FFL violate 933?
Yes.
Can an FFL who is filling out all the forms violate 933?
Yes.
So doesn't that show there's not a complete overlap between the two statutes, regardless of how we construe them? Like, one of these statutes is about selling to anyone you know is not allowed to have a firearm, and that's a prohibition that applies to you whether you're an FFL or not. And then there's another statute that says, subject to certain exceptions, yada, 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 you can't sell firearms without a license. I mean, I understand those are overlap, and I understand that some of the people who are subject to regulation could violate both statutes. Mm-hmm. But I don't see how it renders them redundant, because if an FFL who has a license and scrupulously fills out all the forms and does all the other regulatory stuff, if that person sells to someone they know is illegal, is not allowed to possess firearms. That FFL has violated 933, right?
I hear you, Your Honor. And
How would the statutes be redundant then?
I think really we're just trying to focus on that there is some overlap, but there also is not overlap. And that is the critical component when we're evaluating categorical approach cases. It's whether every single offense under 922 could also be trafficking in firearms. That's what we're considering.
Okay. Can I ask you another? So in your brief, you presented as an argument about 933, and then you said this 933 supports you, and then this guidelines provision supports you. But does that guideline enhance the offense of anyone who's convicted under any statute other than 933?
Yes, it does.
Okay. What other statutes are those?
It includes a host of statutes under 922.
Okay. So I guess I know you're starting to get low on time, and I want to give you a chance to wrap up, but could you just walk me through what you think the significance of the guidelines? So I think I understand your argument about 933. Could you tell me sort of the capsule summary of your argument of the guidelines provision?
We think it confirms that definition, trafficking in firearms, because it too reflects that unlawful transfer to an unlawful participant or recipient. And that's important because the sentencing guidelines, whereas 933 was enacted in 2022, we have further evidence that contemporaneous to the time that the INA passed the aggravated felony provision for trafficking in firearms in 1991, the sentencing guidelines too give an enhancement, provide an enhancement for what looks like trafficking in firearms behavior as we've defined it through 933.
Before you run out of time, isn't proof of profit an issue in this case? Is proof of profit an issue in this case?
In our alternative argument, we present a proof of profit exception.
So what's your argument?
If this court were to accept the board's definition of trafficking as trading or dealing, under the proof of profit exception, there is no requirement for a bargain for exchange or a two-sided exchange. In fact, in the proof of profit exception, we see the word disposition used, whereas in other parts of 922, we see sale or exchange. Disposition insinuates that it's a one-sided action or behavior that one is taking. So under the proof of profit, one could be found liable under 922 for giving away a gun with the purpose of committing criminal acts or for also perpetuating terroristic acts. And so,
My other question was, like you started out by saying categorical approach. Do we use the categorical approach or the modified categorical approach in this case?
we use the categorical approach in this
And
case.
why?
We believe that the statute is not divisible, and that we have seen from this circuit that based on the actions or the verbs being used, I see I'm out of time, may I briefly
You
complete?
can answer, of course.
Thank you. That we do not divide statutes based on the actions, so long as the actions that we are contributing to the same purpose, the unlicensed dealing.
You've got some time on reply. Thank you, counsel.
Thank you.
Good morning, and may it please the court. My name is Catherine McKinney, and I represent the Attorney General in this matter. Your Honors, petitioner's offense under 8 U.S.C. 922A1A is categorically an illicit trafficking offense under 8 U.S.C. 1101A43C. The board's definition of illicit trafficking as unlawful trading or dealing is the best reading of the statute, and the court should adopt it as its own. Using the traditional rules of statutory construction, the agency decision here in this case is correct. First, turning to the plain language or the ordinary meaning of the text of the statute here at the time of enactment, here the board appropriately used the ordinary meaning of illicit trafficking as unlawful trading or dealing based on the dictionary definitions at the time. The board in matter of Davis cited to Black's Law Dictionary from 1979, which defined trafficking as trading or dealing. And as the Ninth Circuit in Chacron observed, this definition of trafficking as trading or dealing is pretty much consistent from that time until present. So this definition comports with the plain language of the statute. Also comports with the structure and context of the statute. Here we note that there's an omission of a specific statutory cross-reference with respect to trafficking, and certainly Congress could cross-reference, had it intended to cross-reference one of the statutes, including the two that Petitioners' Counsel advocate for, but they didn't. Additionally, looking to the context here, there's a presumption, there's a normal rule that identical words used in different parts of the same statute carry the same meaning. And here, this interpretation is also consistent with the Supreme Court's interpretation of trafficking in Lopez to mean commercial dealing. It's also worth noting that the board's decision here, or the board's definition of illicit trafficking as unlawful trading or dealing, is consistent with all the Circuit Court of Appeals precedent interpreting that term for purposes of 43C. Most notably, as noted in the government's brief, the Ninth Circuit in Chacron analyzed this issue and noted that the board's definition, as found in matter of Davis, was persuasive. Whether or not the court there applied Chevron deference or Skidmore deference, even a lesser form of deference, the board's definition was persuasive, went to the board's reasoning, the board's looking to the dictionary definition for a determination of what these words ordinarily mean at the time of enactment, and found that persuasive.
So, for purposes of this question, let's just assume that I'm aware of, we start with the text, and if the text is unambiguous, we end there, and we may never get there, blah, blah, blah. Just assume that I'm fully aware that you're gonna say all those things in response. Assuming for the sake of argument, we were to consider these statements from the legislative history, what do you suggest that we make of the fact that it sure seemed like a bunch of Congress people in the congressional record didn't think the pre-existing law was a trafficking statute, right?
I think you're referring to what, there's some of the legislative
Yes,
history
the
noted in the
legislative
briefs with
history
like,
line. And
this doesn't.
Your first order of argument's gonna be, that's not what this text says, we don't, I know all that. But let's assume for the sake of argument that we get to considering, what do you think those statements are about?
Two responses. If I remember correctly, the legislative history cited in that brief that it doesn't do with respect to trafficking what we need it to do now. So it doesn't mean that there wasn't a provision addressing trafficking, but perhaps they needed something more explicit if you're referring to the most recent 2022 illicit trafficking position, that it didn't do what it needs. It doesn't do with respect to trafficking. I believe there was an additional clause there. But the second thing.
So what it didn't do is the thing that I asked your friend on the other side, like, the existing law doesn't tell a licensed FFL you can't sell to someone you know is not allowed to possess firearms? Is that the thing that was missing?
That I'm not entirely sure what they were referring to as the thing that was missing. And then to respond, I guess, in second way to your question.
Don't tell me you can't figure out what the legislative history means. Please don't suggest that.
The other, if you do get there to that point, if you look at page 36 of Respondent's Brief, looking at the Gun Control Act enacted in 1968, there's at least some reference there to what they're trying to address is in part the traffic in firearms. I mean, perhaps we didn't use the exact words illicit trafficking like we do in the most recent one, but I don't think that it would support the proposition that there was nothing addressing the unlawful traffic in firearms. And again, only if you get there.
Sure, I understand. And so, speaking of illicit, like, I will say, just as a matter of initial preliminary, well, let me ask a threshold question. As I read the government's brief, you understand illicit to essentially mean unlawful or unauthorized, right?
That's what the board said in matter of Davis, and that they were relying on blacks for that. And I believe it was unlawful, prohibited, but essentially they narrowed it down to unlawful.
I will say, for what it's worth, my gut reaction to that word is that that's a weird way of, like, first of all, it's just unnecessarily fancy for no apparent reason. But second of all, when I think of illicit, I guess in plain ordinary, we start with the text. I would say that for me, that's not the most obvious or inevitable definition of illicit to me, right? I mean, there's another alternative connotation of illicit that to me is like surreptitious or secretive or furtive, right? Like, so what do I do with the fact that for me as a matter of plain meaning, it doesn't strike me as obvious that illicit just means unlawful?
Well, I guess the response to that would be that you can look to the dictionary as the board did, looking to blacks, and that's how blacks defined it, as one way of evidencing what the ordinary meaning would be at the time. And it sounds like Your Honor might perhaps be a bit skeptical as to that's all it encompasses with the dictionary definition. And I think it might be helpful for Your Honor in that question with respect to licensing and consent with the licensing type questions. I believe the Second Circuit in the Kuhali decision in 2001 does have something to say, or at least they rejected a similar argument there, because there the argument was that the act of exporting firearms was prohibited only in the absence of a valid license, and then what the Second Circuit was responding was that's immaterial if it was unlawful, and then of course if the definition of trafficking had been met. So I think that might be helpful to Your Honor, and I do believe that's on page 108 in response to there. And also just going back that this has been a consistent interpretation. Davis was 1992, and the courts that have addressed it since have uniformly not had issue with it. Many of them have deferred to that, both in the 43B context and in the 43C context. So this is a fairly consistent definition going forward, which would lend support to the proposition that it meant then and it means now exactly what the board and the circuit courts that have addressed it have determined that it does. So it's the government's position that the agency's decision is correct from the plain language of the statute, and even if that wasn't clear, the agency's decision is deserving of respect under Skidmore, which is what the Ninth Circuit in Chacron was willing to say. It was persuasive at a minimum, even if you didn't apply Chevron deference. So we urge...
Because we literally can't apply Chevron.
I'm just acknowledging that some of the decisions before there did defer applying Chevron, but the Ninth Circuit decision was saying that applying Chevron or applying Skidmore, which is what's available now, that the board's decision was persuasive. So we urge the court to adopt that definition as its own. Turning to the application of that definition to the offense at issue here, it's the government's argument that that offense is a categorical match to the board's definition of unlawful trading or dealing. And this court should find the same way that the Ninth Circuit did in Chacron when they were analyzing the same statute, and they found that it necessarily entailed unlawful trading or dealing. That statute prohibits anyone, except someone who's licensed, from engaging in the business of importing, manufacturing, or dealing in firearms. So here, by its very definition, it's categorically someone is engaging in the trade or dealing of firearms, categorically with that language. And then, of course, we have unlawful met by the fact that you're not lawfully doing it here. So this court should find, as the Ninth Circuit did, that there's a categorical match. And as to get to your Honor's question about the proof of profit exception, the government disagrees there that that would carve this out of the definition for the reasons that we've noted in the brief. That exception only applies to whether or not the government has to prove profit. But the exception only applies if everything else that is elaborated in the statute applies there too. So you still have to be engaging in the business. You still have to be engaging in business as is defined further in the statute in 921. And that means regular and repetitive purchase and disposition of firearms. The only thing that the proof of profit exception goes to is whether or not the intent has to be predominantly for profit motive, or if there can be an additional motive or an additional predominant motive. So it's the government's argument that that wouldn't pull it out of the unlawful trading or dealing definition, because it would still be unlawful and you'd still have trading or dealing. So the government argues that this court should adopt the board's decision for illicit trafficking as unlawful trading or dealing, and also that this court should conclude that petitioner's offense is a categorical match. If the court has no further questions on the other issues, like venue, then we urge the court to deny the petition for review. Thank you.
Thank you, counsel.
Three points on rebuttal, Your Honor. First, on Skidmore. Second, on the full phrase of illicit trafficking in firearms. And three, on the proof of profit exception. Under Skidmore, my colleague says that courts have deferred to the board's definition of trafficking in the 8 U.S.C. section 1101 A43C context. We've seen that. It's the only decision that we see that in Chacon out of the Ninth Circuit. And one thing that court did not get the opportunity to consider was Congress's confirmation of the definition of trafficking in firearms in 933. We think that's an important distinction that should lead this court to find persuasive 933 is relevant, is indeed a closely related statute, and is persuasive in this case. On that note, my colleague also mentioned...
Can I ask a question? I just can't help, because my good friend Judge Heitens wanted to talk about the legislative history, and so I just can't help myself. So when I read the legislative history, it seems to read the opposite of what you're telling me to say, right? So you're suggesting that 933 defines the waterfront of what trafficking means, right? So that trafficking means what 933 says and nothing more. But the legislative history, at least the, friends that you've picked out of the crowd here, says that there's no statute prohibiting firearms trafficking in the way we need to do it. Doesn't that actually suggest to us that there are other ways in which it is being prohibited, but like this way, that is, to prohibited end users, has not been addressed? Doesn't that actually sort of suggest that your reading of 933G is just wrong?
Not-
It's only one way of trafficking a firearm?
Not necessarily, Your Honor. In the context of legislative history, it's very possible that that statement suggests that states are criminalizing certain types of conduct, but that trafficking in firearms as a federal offense has not been applied.
Your suggestion, I mean, I get we're trying to read it for all it's worth, but you're suggesting that the Congress was saying there's no criminal statute prohibiting firearms trafficking in the way we need to do it, that's a reference to states?
Well, I think it's definitely possible because under the categorical approach, as we know from Esquivel-Quintana, we look at state criminal codes as well. I think Congress would have a reason to confirm that definition in 933, in writing 933, if it did not believe that either states, state courts, or other courts were not applying it in the way that was as clear as possible, as clear as day, as we have it in now black ink. To my second point, the government does not provide a definition for the full phrase illicit trafficking in firearms. This is important because dictionaries don't give us a definition either.
Can I ask if you considered using corpus linguistics to sort of do this? I mean, the typical move that we're making, where you have a different meaning based on context, like corpus linguistics seems like the tailor-made tool to use there. Is that, I mean, I just wondered why I didn't see that.
I think that it could be relevant, Your Honor. I think we wanted to stick or hew closely to Congress's own words, which is why we believe the right definition is what Congress put forth in 933. As there is no definition for trafficking in firearms, we do see in Black's Law Dictionary, however, there's a definition for human trafficking or trafficking in persons. There's also a definition for drug trafficking. That's why we believe, when there's no definition for trafficking in firearms, that the government's use of dictionaries falls short. And that's why we start to look at other sources, as the Supreme Court has.
Thank you, counsel. As we have a tradition in the Fourth Circuit where we come down and greet counsel, given the particular circumstances, Judge Heitens and I will come down and greet counsel, and would ask for you to come up to the bench and greet Judge Floyd up here.
It would be an honor. Thank you.
Our next case is 24-1380 Frazier versus Prince George's County. Ms. Cookshank, please don't rush, but we'll hear from you whenever you're ready. Happy to hear from you, counsel.
Thank you. May it please the court, Elizabeth Cruikshank, on behalf of plaintiffs' appellants, I'd like to reserve 4 minutes for rebuttal. This lawsuit is about a class of presumptively innocent people who are being detained pending trial under an unconstitutional system. But this appeal ultimately turns on a handful of straightforward immunity doctrines, which the district court significantly misapplied. The county is categorically ineligible for quasi-judicial immunity from any of plaintiffs' claims. The Supreme Court and this court have repeatedly reaffirmed that counties are ineligible for absolute immunities under any circumstances. And every court of appeals to reach the question, now 7 courts of appeal in total, have applied that prohibition to quasi-judicial immunity in particular. Neither the district court nor the county has identified a single case to the contrary, nor are we aware of any. That alone requires reinstatement of all of plaintiffs' claims against the county. As for the judge defendants, plaintiffs only ever sought declaratory relief against them. The judge defendants do not even attempt to defend the district court's conclusion that judicial immunity precluded declaratory relief against the judges. Instead, they rely on a forfeited and unavailable abstention doctrine on which the district court did not base its decision. For these reasons, we ask that the court reinstate all of plaintiffs' claims against both sets of defendants and grant the further relief requested in our brief.
Can we start with the judge defendants? And sort of, at least for my questioning, you can accept as a hypothetical that the district court got it wrong.
Okay.
But can you help me understand how the judge defendants are adverse here? The Supreme Court in Whole Women's Health recently addressed using judges as defendants to challenge statutes. And the Supreme Court pretty plainly said that when judges are acting in their adjudicative capacity, right, so when they're setting bail, for example, that suing them for injunctive or declaratory relief is outside of Article 3 because they're not adverse, right? Adversity is one of those requirements that Article 3 sets forward. And it can be complicated in lots of ways, but it seems after Whole Women's Health, it's not complicated with respect to judges who are engaged in adjudicative work. And I understand the district court didn't address this argument, but it's jurisdictional, so that doesn't help me any. And I know this is a little bit of a spring on you because the parties haven't argued Whole Women's Health, but do you have thoughts about that, or do you have any sort of places that you think I should look to understand how a judge exercising its adjudicative capacity is adverse to your clients?
So the Whole Women's Health question in particular is about judicial enforcement of statutes, and that's not what we're challenging here. We're not challenging sort of how the court is applying a statute. We are specifically challenging the particular conduct of the judges. And so in that sense, I think judges are in the same situation as any government official who is committing an unconstitutional act directly against the plaintiff parties.
But is doing so by adjudicating a claim, right? So they're before the court, right? There's the defense and there's the government, and they're making an argument to the court about release or bail or conditions or no conditions, all of the same arguments we hear about in bail. And the judge is acting in an adjudicatory fashion. It's saying, I've heard the arguments, I've looked at the evidence, I have decided X, right? That strikes me as like precisely the adjudication function of the court. And I take Whole Women's Health to just categorically say that in that context, you can't bring a declaratory injunctive relief against the judge, him or herself.
I don't read Whole Women's Health as going that far. I think it was about the specific statutory enforcement scheme at issue in that case. I would also say that plaintiff's claim is not challenging the actual adjudication of any particular bail determination. We are not saying the judge got it wrong in any particular case or that any of our plaintiffs ought to have been released by a judge when they were not. We are not seeking sort of immediate release. What we are saying is what the judges are doing is improperly delegating their adjudicatory function to a non-judicial entity.
But why isn't the remedy for that to appeal?
Why isn't the remedy for
To
that?
appeal. You think, another way to describe what you just said is that you think that trial judges are sometimes, often, most often, getting a question of law wrong. Traditionally, the remedy, if you think a trial judge has gotten a question of law wrong, is that you appeal that decision. You don't file a lawsuit in federal court attacking collaterally, essentially, a series of decisions made by state court judges.
So this isn't this isn't a collateral attack on the decision itself. It's an attack on the system of declining to adjudicate and instead referring the adjudicatory decision to the county. From a
But
practical perspective.
You frame it that way, right? But when I look at the orders, right, the orders say the defendant is committed without bail. Like, that's an adjudication. Like, that's a ruling by the court, right? It then goes on to say, this, what they call the option, right? But whatever that is, like, I don't see how that's not an adjudication.
We're not challenging the held without bond piece. We're not challenging the adjudication itself. We are challenging the wholesale delegation to the county subsequent to whatever has gone on in the proceeding. And to the question about, to Judge Hyten's question about appeals, as a sort of jurisdictional matter, 1983 doesn't require exhaustion of any particular state processes, which I think is sort of the appellate question. As a factual matter, appeals are not available to our clients in these cases because
They're just not available as an appeal. They're available under habeas, right? You do it under Maryland Rule 15302. Like, you can challenge it. It's not called an appeal, but it's effectively an appeal.
But again, we are not seeking immediate release or the shortening of detention, which is sort of what habeas is getting at. We are challenging a process that exists outside these actual adjudications.
But isn't that exactly what they were doing in Whole Women's Health, right? They weren't challenging any given, decision. In fact, there hadn't been decisions yet, right? But like, they're just trying to tell the state court judge, you gotta do X. Like, we declare that this is the way you must resolve the claim that comes to you. And the Supreme Court pretty clearly says, can't do that, right? If the state court gets it wrong, you can appeal, right? And so if the state courts are getting it wrong here, I mean, I'm extremely sympathetic as a factual matter to the situation you find yourself in. I don't understand why you didn't file 30 habeas claims here and get state courts to address your problems. But I can't figure out how I'm supposed to tell the state court judge by declaration or injunction how it's supposed to act, because they're not adverse to you. They're just trying to decide cases. You think they're doing it wrong. Not fine. Maybe, I don't know.
They are adverse to our clients in the sense that
Why? Why are they adverse in a way that they were not adverse in Whole Women's Health?
well, just as a general matter, they are adverse in the sense that they are government actors who are subjecting our clients to an unconstitutional scheme through these improper referrals to the county.
And so that would be every state judge, any state judge who makes any decision that you think is improper is subject to being enjoined and declared to be acting unlawfully.
No, because again, we are not challenging the bottom line adjudication in any particular bail review hearing. We are challenging the overall scheme of deferring decision-making altogether to the county, which is categorically different from a judge making a decision that we disagree with. And these questions sort of sound in Rooker-Feldman, Rooker-Feldman being about state court losers running to federal court and trying to overturn adverse decisions against them. We are not trying to overturn adverse decisions. We are trying to get the judges to decide the law as they are supposed to, and that is quite
Decide differently, right? So instead of deciding to suggest that somebody has to be a custodian, you want them to decide it differently. I totally get that you want them to decide it differently, right? But why are they adverse to you, right, in the way that Whole Women's Health talks about it? Like, what about, like, they're just deciding cases, right? They get the bail to them, they look at it, they decide it, and part of their decision, as the statute permits, is to, like, require a custodian. The custodian's the county, they send it to the county. I guess I'm just totally can't figure out what your argument as to why they're adverse as judges.
We don't believe that the judges are looking at a statute and saying, I think the statute entitles me to just send this to a custodian, in the sense of issuing a pretrial detention order subject to custody. We think the judges are wholesale handing over their adjudicatory authority to a different body, which is categorically different from a case in which a judge renders a decision that we don't like. And again, I do want to mention the appeal question. As a practical matter, appeals are not available to our clients in these cases. When our clients have...
Do you think 15302 doesn't permit you to bring a habeas challenge to a bail determination?
I think we could, but I don't think 1983 requires it.
But that's different. You just said an appeal is not available, right? What I'm saying is, it's not called an appeal, but it's effectively an appeal, right? That's what habeas is.
I think that that would be true of any challenge to an unconstitutional pretrial detention scheme, that in theory you could proceed through other state court mechanisms, but you're not required to. And the Supreme Court has repeatedly blessed and recognized lawsuits in the context of unconstitutional pretrial detention schemes.
Oh, go ahead. No, awesome.
Can I take you to the motion to quash?
Sure.
Is there any way for us to rule for you on that without creating a circuit split? Doesn't the Fifth Circuit's decision, is there a way that we could say that you can get discovery that would not put us in direct conflict with Russell versus Jones?
I don't think that this court has to engage with, I believe, the state sovereign immunity questions that were at issue in Russell versus Jones. I think the court at this point, if it wanted to, could simply vacate the grant of the motion to quash as premature, because that's ultimately what we were saying, is these privilege questions need to be decided on a question-by-question basis in the context of actual decisions in a deposition or in live testimony, and can't be done on in a blanket way. I frankly don't think that state sovereign immunity bears on the judicial deliberative process privilege.
I guess I'll just take does it not at a high level of generality seem extremely atypical that what we're going to do is we're going to have a deposition and we're going to ask judges, please describe the process by which you describe cases? That seems very odd and atypical, right?
We are not, again, specifically asking...
I know you don't want to say, I'm not asking you how you decided Bob Smith's bail, but you do want to ask them, describe the process by which you make these decisions. You do want to ask them that, right?
We do want to ask them about their
You
general...
don't normally ask judges questions like that under oath and depositions where they're subject to compulsory process, right?
That's correct. We don't normally. This is an unusual case involving an unusual unconstitutional system. We do point to cases in our brief in which judges have been made to sit for depositions and in which judicial staff have been made to sit for depositions under various circumstances. There are a number of challenges to not exactly this system, but to other pretrial detention-like systems in which judges have been made to sit for depositions to kind of understand the general policies and practices that are going on. I'd point to the Feltz case, the McNeil case in New Orleans, the Kane case. There have been, and in the In Re Certain Complaints case in the 11th Circuit, where judges and their staff have been made to sit for depositions. I agree that it's not something that happens every day in federal litigation, but it's not unprecedented. I do also want to get back to the circuit split question. I don't read Russell versus Jones as being consistent with In Re Certain Complaints. And so I think there may already be a festering circuit split as to the susceptibility of judges and their staff to sit for depositions that would not be, that this court might have to wade into in any event.
Can I ask you a question about the county?
Yes.
Can you describe, like, in as much detail as you can for me, what the, like, policy, custom, or pattern or practice is? Like, what have you alleged that the county is doing distinct from what the judges are doing or have done? If I accept as a hypothetical that the judges were gone and I was just looking at the county, what is the policy, custom, practice that satisfies Monell?
So the county has never challenged that there is a policy that we are...
I understand. I'm asking you what it is. They may not challenge it, but I'm asking you,
Understood.
what have you alleged it to be?
So this is pages 32 to 35 of our complaint. Basically, what we are saying is that when the county receives a pretrial referral, it throws that person's folder in a pile, essentially, and defers weeks, if not months, before deciding whether, in its independent view, that person is eligible for release into the community. And so what that analysis looks like is the county has come up with a set of criteria, both the sort of levels criteria, the levels on which someone can be released and how much supervision there's going to be needed, as well as a specific criteria that it has devised as to whether it thinks someone should be released at all. And those include the factors that judges are meant to consider, like the severity of the offense, prior criminal history, whether the person has an address, a verifiable address in Prince George's County, but also factors, so in addition to factors that the judge already considered, also factors like whether the accuser, whether the complaining witness consents to release into the community.
Totally understand that, but, so I take what you're saying there is that there are two things that you're alleging are unconstitutional. One is a delay, right, that they have a policy of delay. And the second is that they are exercising independent judgment, and you've given the things that they're considering, but I take what you're saying is that independent, sort of unconstrained discretion? Like, are those the two parts of the policy that you're, like, complaining about? Because I totally get the first one, by the way, bracket delay for a minute, right? But the independent judgment is doing what the court has ordered it to do, right? Determine whether you think this person should be released. That might have been a bad decision by the judge, I totally get, right? But why aren't they just doing what the judge told them to do in that second part?
I want to clarify, are we talking about quasi-judicial immunity, or are we talking about sort of a merits question of whether they're doing what the...
Well, so I'm talking about adverseness, but I'm asking a more specific question that informs my view of adverseness with respect to the county. So what I'm asking is sort of slightly more specific. It's sort of like a factual question as to what the nature of your claim is, because you might imagine that the nature of your claim will affect at least my view on whether such a claim falls within our jurisdiction.
So the judges are not ordering the county to do pretty much anything that it is doing, in the sense of the court has not set, nor is the court apparently aware of the criteria by which the county makes these decisions.
It just gives broad discretion, right? The judge says, county, you got broad discretion. Release them if you want them. Effectively, right?
Yes.
I totally get why that's a problem from your perspective. I understand it, right? But the question is, like, that just tells the county, release them if you want them. And so if that's what they're doing, why isn't that just pursuant to the judge's order?
So first of all, they are not following anything that is set out in the four corners of the judge's order. They are doing their own discretionary analysis that the judges are not overseeing. This is all happening in a black box with no adversary proceeding or any of the other procedural safeguards that we look for. But also, even if they were just following orders, there's ample precedent that state actors or government actors cannot evade their constitutional obligations by saying they were simply following the orders of a court. That's the McNeil case from the Sixth Circuit. That's Moore versus Urquhart from the Ninth Circuit. Just following orders is not actually a defense for acting unconstitutionally. I do see that I'm quite low on time. If I can reserve the remainder for rebuttal. Thank you.
Thank you.
Good morning, panel. If it pleases the court, my name is Andrew Murray. I represent Prince George's County, Maryland. Judges, in Prince George's County, Maryland, the county, through its Department of Corrections, at its initiative and at its expense, has opted to provide a pretrial release program in support of its local criminal justice system. It exists for the purpose of supporting the local criminal justice system. In this particular case, the plaintiffs have alleged violation of their due process rights because they claim that the courts, the judges, have abdicated their constitutionally mandated duty to afford plaintiffs, those criminally accused, with due process rights in bail and bond review hearings, and instead abdicate that responsibility in favor of the executive branch, those employees at the County Department of Corrections who man its pretrial release unit. Now, concededly, the court resolved this claim, these cases on a 12B6 and a 12C motion on the narrow.
I realize you're the messenger here.
I'm sorry?
I said, I realize you're the messenger here, but one thing that's sort of frustrating is it felt like we remanded this case with instructions to figure out what's actually, I just remember the previous appeal, it was in this building, and one of the things that happened at oral argument is everyone's like, what are the judges actually doing? And the previous argument, the parties were just diametrically opposed about what the judges were actually doing. And at least as I understood our remand order, it was, please make some findings about what the judges are actually doing. And now I'm confronted with a ruling on a motion to dismiss. What am I supposed to do with that?
Well, I think the court made those findings, Your Honor.
You can't make findings on a motion to dismiss. That's what a motion to dismiss is.
The court looked at the allegations as pled. It looked at the operation of the Maryland Rules of Criminal Procedure and found that the plaintiffs had not plausibly alleged a cause of action in this case.
Wait, that's not what the court said. What the court said was, with all respect, shall we say, aggressive out-of-the-box theory about why a county can have immunity despite literally decades of precedent saying counties have no immunities of any kind. So that is a little strange, right?
Your Honor, I would concede that there's ample authority suggesting that.
The district court also dismissed people who'd already been released despite very clear authority from the Supreme Court and this court that said, if you file a putative class action, the fact that you later get released does not moot your claim, right?
Yes, Your Honor.
So I'm back to, I don't really know what to do with all of this.
Well, Your Honor, I think it's relatively, frankly, simple to resolve because there have been no allegations that anything the county has done is in violation of any court order. There are no habeas petitions before the court. There are no contempt findings against the county.
Local governments constantly violate the Constitution without violating court orders, right?
Well,
lots of things violate the Constitution that aren't compelled by court orders.
Your Honor, respectfully, and I made this argument in the brief, the county has opted to provide this pretrial release service voluntarily.
Now we're back at the bitter with the sweet. You just saying we didn't have to do this so we can do anything we want is also something that in the due process context we've rejected decades ago, I think.
What do you take the policy to be for the county, right? I take your colleague on the other side to say that the policy, because Monell tells us that we've got to have a policy, right? And I understand you haven't challenged the Monell piece yet, but we got to understand what the nature of the claim is to evaluate things like our jurisdiction. I understand there to be sort of two parts to it, but I want to get your take on it. Yeah. There's like a delay piece, which is sort of distinct from this sort of exercise of unfettered discretion. Can you help me understand what you think the alleged Monell policy is? I understand you probably think that it doesn't work, but just help me in understanding what the alleged policy is.
Well, I understood it as the court did when it previously questioned appellant's counsel about it. It's the delay and the criteria utilized by the pretrial release personnel with essentially utilizing their own discretion and without the oversight of the court.
So imagine for a second that we had a case where the judges did exactly what the judges do, and the county instituted a policy that said, in the exercise of our unfettered discretion, we are only going to release people of a certain race. Do you think that they could bring a claim on that basis and say that's like they've adopted a policy that is considering race as part of their discretionary judgment? that the court plainly gave them, right? The court said, you can exercise your discretion, right? You got to decide whether you think there's, can be supervised or not, right? But if the county, and I'm in no way suggesting the county has done this is obviously a hypothetical. If the county said, we're only going to release black people, that's it. No white people, no Hispanic, no Asian, nothing, just black people. That's the only people that we will supervise. Don't you think that that would be a claim that could be brought because they've adopted a clear policy that is clearly unconstitutional, and the fact that the judge told them they had discretion doesn't seem to solve that problem?
I would agree with the court that that presents big constitutional due process problems.
How about another? We won't release anybody who doesn't post a $100,000 bond, no exceptions, don't care how poor you are.
Again, well, Judge, those are decisions for the court to make, but.
No, the court says, as I understand Judge Richardson's question to be, the court says the county is authorized to release this person on such terms as the county thinks is appropriate. So when the county imposes that policy, it's not violating anything the judge told them. The judge said release under criteria that you think are appropriate, and then the criteria that are announced are flagrantly and obviously unconstitutional. It seems pretty obvious to me that would be a county policy and you could sue the county, right?
I would agree with that.
So why is that different than this?
I'm sorry, Judge?
Why is that different than this? I mean, I understand that you don't agree that what is happening is actually unconstitutional. I imagine that if this case gets past a 12b6, there will be a robust disagreement between the parties about what's actually happening. But if we're at a 12b6, we have to take the plaintiff's account of what's happening. And if the plaintiff's account is true, why doesn't that sound like a policy, and maybe a policy for which the county is responsible? Because the argument is, no one is saying, I guess another way to describe this question is, do you disagree that as a descriptive matter, some of the people that the plaintiffs would like to have be released, the county could release without violating the terms of any judge's order? So one of the allegations I think in the complaint is sometimes we don't let people out because they don't have an address in the county. But the judge's order doesn't say you can't release people who don't have an address in the county. Ergo, if the reason they're not being released is because they don't have an address in the county, it's because the county, not the court, has decided not to release people who don't have an address in the county, right?
Right. But the county has to have some parameters within which it can make these decisions.
Totally fair, but that's a merits question, right? That's what you're saying is that the criteria they're using are legitimate. They're not using race. They're not using wealth. They're not using age. They're not using something that's illicit. In fact, they're using totally reasonable things. You might be right on the merits. I wouldn't bet on it, but you might be. But that's a merits question, right? We don't have that question, right? It's a totally different inquiry if we're asking whether that is actually a violation of the Constitution or not. We're at the threshold step, right? Do you get to have discussions about the merits?
Not at the 12b6 or the 12c. Yeah. But in the record before the court are those criteria, and the court can look at them and see that there's nothing violative of due process about them. The county can't possibly be expected.
You get that we don't typically do that, right? We don't typically get a case that was dismissed on immunity grounds, contrary to decades of law. And then turn around and decide on the merits that, there's no due process violation, right? I mean, that's just not how we typically do things. Right?
Understood, Judge.
Do you have just jumping back to the judges, do you have anything you want to add about the judges and Whole Women's Health?
I don't, Your Honor, and I'll leave that to my colleagues from the state to argue.
Yeah, thank you.
Thank you.
Good morning. May it please the court. There were a lot of questions a moment ago with regard to the county about whether this is proper for or dismissal was proper on a 12C motion to dismiss on the pleadings. While it may not be, while the court's asking a lot of questions as to the county, and there may be questions as to whether that was proper, there should be no questions whether that was proper as to the judge defendants. Please allow me to explain. And prior to going in,
Just to make sure I understand, do you mean proper in the sense of the district court judge got it right in applying judicial immunity for prospective relief? Or do you mean the district court reached the right place by dismissing the judges, even if it followed the wrong path to get there? Are you defending the actual path of the district court here, or are you just defending where the district court ended up?
both, Your Honor.
All right. So tell me why judicial immunity applies to prospective relief?
During the last oral argument here before this court relating to that exact question, the plaintiff's counsel was asked, why doesn't judicial immunity bar plaintiff's claim for declaratory relief? And the response to that exact question was simply a reference to Section 1983. And then the statute was cited. Then, in response, the court said, well, we're familiar with the statute, and asked for cases. The cases were cursory reference to Polium, Timmerman, and other cases that went unidentified. Since that time, and in the plaintiff's briefing, and not once has there been a case throughout the argument here, throughout the briefing, where the plaintiff's counsel has identified a single case from this court that said judicial immunity does not apply to prospective declaratory relief. The reason is, it doesn't exist. That case doesn't exist out of this court, speaking to whether judicial immunity will apply to prospective declaratory relief.
Give me the cases you want us to look at that say the opposite, that say what you think is right, which is that judicial immunity bars declaratory and injunctive relief.
Thank you, Your Honor. There are cases out of the First, Third, and Sixth Circuits, as well as the Fifth and the DC circuits, that talk about, generally speaking, they don't look, as the plaintiffs want you to do, to look specifically at the statutory language of 1983 and come to the conclusion that judicial immunity does not apply. Rather, these cases look at and consider the fact of the 1996 amendments to the Federal Courts Improvement Act, and they come to the conclusion that you can't get declaratory relief against judges, and it's because they're committing judicial acts.
Your representation is those cases say that you can never get declaratory relief against judges based on the amendment to 1983.
Generally speaking, yes, and that would be the Guzman case out of the First Circuit, 2019, Allen, out of the Third Circuit, 2017, Cooper, out of the Sixth Circuit, Bauer versus Texas, out of the Fifth, and Roth versus King out of the DC Circuit. And generally speaking, they come to the conclusion that as a result of, despite the 1996 amendments to the Federal Courts Improvement Act, you do not follow the plain language reading that the plaintiffs would have this court apply to this novel case of whether judicial immunity, this case, the first time this court has been presented with, would judicial immunity apply to prospective declaratory relief here? Those cases, we would implore the court to apply that analysis of those cases.
Which is you agree is contrary to the plain language of the statute.
I don't agree it's necessarily to the plain language.
I thought that's what you just said, right? They said they rejected the plain reading of the statute and instead sort of like said, despite what the statute says, we're gonna do it anyway.
What I meant is rejecting the plaintiff's argument that you apply a plain language reading of the statute, because when you
Because when you read the plain language of the statute, it's not very good for you, right?
I would say it's not very clear, Your Honor. Not that it's not, based upon plaintiff's contention of how the plain reading should apply.
Can you
it would not
at least talk for a minute if you would like to, about whole women's health and at least address the theory that even if the district court got off of the path here, it ended up in the right place because judges are not adverse to those that appear before them?
Well, absolutely. And before specifically I answer that question, in reference to a similar question to plaintiff's counsel, they made the point that that there was not a statute here that was allegedly violated. I think that was generally the language used in the argument. But this is a rule. All this case comes down to is the state court judges applying the Maryland rule that allows them to refer these detainees, these criminal defendants, to pretrial, and it says that you'll only be released if they agree to supervise you. The rule allows it. In answer to your question,
Is that what I think is whatever it is 216(1) D2K, right? This is committing the defendant to the supervision of an organization that agrees to supervise?
yes, Your Honor.
That's the rule or statutory basis for the order that's being entered.
Yes, Your Honor. And in reference to whether the judges are adverse here to criminal defendants, absolutely not. There's no difference between this criminal defendant, or sorry, these criminal defendants, these 9 who filed this action, and every other litigant that appears before these judges. If somehow the plaintiffs could allege that they're adverse based upon the circumstances of this case, it opens the door and kind of, it circles back to the judicial immunity argument. It opens the door, and this is what I think the district court, though may not as eloquently as they could have described, as this is the threat to every state court system.
Can you help me understand? If an individual plaintiff here wanted to challenge their bond decision, can they do so by 15302, the habeas statute, under Maryland law?
Absolutely, and they could also ask for the Supreme Court of Maryland to issue a writ of mandamus, but more importantly, in every one of these cases, Your Honor, every request to come back to the trial court for a bond review hearing was heard. They've never been denied, so at any time.
Well, but you might think that, like, getting to go back before the same judge isn't quite the same thing as an appeal, right?
Oh, well, no, Your Honor, that's not necessarily the same judge. The record reflects here they're different judges.
Same level judge, right? They're different judges. I get after the first one is a lower, and then, but the reconsideration is all by the same level, no?
No, not exactly, Your Honor, because these cases can move from district court, which is the lowest level trial court at the state of Maryland. And I see my time is up.
You can answer.
Thank you. But some of these cases then move up, as in Mr. Butler's case, for example, who was convicted for second-degree murder, pled guilty. It moves from district court, the case moves from district court to circuit court. They see a whole other level of judges at that point. So it's baked into the process here. You refer to it as appeal, habeas corpus, however the court wants to frame it. But nonetheless, and it happened in these cases, they can keep coming back even after this alleged delay by the county. They can keep coming back to the same judge, a different judge of the same court, or if the case ends up at the circuit court level due to the higher level criminal charges, it can be heard by a completely different judge at a different court. Thank you.
Thank you, counsel.
Thank you.
Happy to hear from you on reply.
Thank you, Your Honor. I have a number of responses to make. I'll try to go quickly. I'll start with declaratory relief against the judges. And as an initial matter, defendants didn't cite any of those cases that they contend say prospective relief is unavailable against judges. At least one of the cases we did cite in our own brief for the proposition that absolute judicial immunity does not bar claims for prospective relief. Supreme Court precedent is clear, Pulliam versus Allen, Morales versus Waco. Common law judicial immunity does not bar declaratory relief against a judge. To the extent that the court thinks that the district court erred in its analysis dismissing declaratory relief, the proper course is to send it back. That's the von Rosenberg case, rather than to sort of redo that analysis in the first instance.
But you agree that's not true if we think that we lack jurisdiction? like, we don't get to just send it back to redo judicial immunity if we lack jurisdiction, right? We gotta determine jurisdiction first and foremost.
If you're speaking to the whole women's health
I am.
question, which I'm happy to submit a supplemental brief on, if that would be helpful to the court, I don't actually think that that state sovereign immunity question is itself jurisdictional. I think that the judges could raise it but have not.
You think adversity is not jurisdictional?
I don't think adversity is not jurisdictional. I think the state sovereign immunity question, which I took to be slightly different, is not. In terms of adversity, this goes to Ex parte Young. Adversity in the context of challenging the action of a state actor looks to whether there is, quote, some connection between the actor and the conduct being challenged. And here what we are saying is that the judges have a policy, not that the judges are adjudicating particular cases in a way that is problematic necessarily, but that there is an overall policy that we are trying to challenge. And there are numerous cases where plaintiffs have been able to challenge judges when they were enacting an illegal or unconstitutional policy separate from their individual adjudications. And I'll just quickly touch on the county, if I may.
And the policy, just so I understand, the policy is to commit defendants to the custody or supervision of an organization that agrees to supervise the defendant. Like, that's the policy that they've adopted.
The policy that they've adopted is altogether deferring decisions as to whether someone should be released into the community, which both the Constitution and the Maryland rules commit to judges to a different body. So
Can I ask a slightly different question? I'll let you get your points out, don't worry. So oftentimes what happens in these scenarios, or at least in some settings, I don't know, Prince George's County, is that the judge says that I will release you if your mama agrees to be your custodian.
Yes.
Right? And so that seems like the same sort of context, right? I'm releasing you as long as your mama agrees to supervise you, or you're somebody else, right? Mama's the most common one. In your view, is that a unconstitutional delegation to mama? Because mama could say it's totally in her discretion to decide whether she wants to supervise her son or not. And in some instances, she doesn't feel comfortable with that, and we don't know what considerations she takes in. I get she's not the actor, but from the court's perspective, the judge's perspective, is your view that common practice is subject to the same challenge that you're making here?
Not at all, for several reasons. And I will note that we're getting deep into the merits questions here, which
Yeah, I know,
ultimately
but
need
it
to be
helps me
hashed out.
understand.
Understood. What you are describing happens in court before a judge, and this is part of an ongoing decision that the judge is ultimately making. Often the mama would be in court, or they would call her and
But not
say-
always, right? Often the question is, if mama agrees, you can be released.
I think as a general matter, the judge is able to make that determination sort of in the moment, and this, or immediately thereafter, and then ultimately what will happen is the custodian will come back to the judge, the parties will come back to the judge and say,
Oh, so-
this is what happened. And
So
what
I
we
take your position is that it would be unconstitutional for the judge to do that, to issue an order that says, if mama agrees to supervise you, then you can be released. But absent that agreement, you can't. That condition, right, given to pretrial, you think that's unconstitutional because that's a delegation of judicial authority to mama?
Not necessarily. I think
I thought that's what you just said, that unless you go back to the judge, that it's an unconstitutional delegation?
I think what happens, and again, we're deep into sort of complex merits questions, but ultimately what needs to happen is the judge needs to be the final decision maker, and often what will happen is the judge will say, I'm going to authorize you released subject to supervision by your relative or whoever it is, and that person can sort of thumbs up or thumbs down. If there's a thumbs down, you're immediately back before the same judge to consider whether there are further conditions that might satisfy public safety. And
Your
prevent
view
flight
is that that's required, that the thumb up and thumb down has to be before the judge, and the judge has to be the one to say, okay, I see your thumb up, so I'm going to release you. That the judge can't tell somebody that? That seems...
The judge needs to be the final decision maker and can't wholesale delegate the analysis that that he is constitutionally required and by rule required to a third party. So yes, ultimately, we take issue with the delegation. It's just the same, and I want to clarify that the presumption is in favor of release. The burden is on the government to prove that there's no condition or combination of conditions that would satisfy the government's interest. So as a general matter, when we are seeing a situation in which the presumption is in favor of release, judges are trying to figure out whether there is some condition or combination of conditions that would satisfy those interests. And so in practical terms, it is almost never the case that there is a single potential custodian or supervisor who could be responsible, but ultimately the judge does need to make that determination. If I may just turn to,
Briefly.
just briefly to the county, Monell isn't jurisdictional. The county has never challenged it. The county has never challenged the existence of a policy. In fact, it has an official operating manual and policy. So there's definitely a policy that we are challenging for purposes of stating a claim. Just as a factual matter, since the question of appeals came up, and my friend on the other side said that the plaintiffs have always been entitled to further review. That's not actually the case, particularly while the county's process is ongoing. Many judges in Prince George's County have an official policy requiring motions for new bail hearings showing changed circumstances and will not accept delays on the county's part as a justification for changed circumstances. So it is not
And that's
actually.
a bar on a 15302 habeas action?
It's not a bar on habeas. We were talking about appeals specifically. So for the reasons stated, we ask that the district court reverse the erroneous district court decision so that we can proceed to these important merits questions. Thank you.
Thank you, counsel. We'll come down and greet counsel, and then we will proceed to our third case of the day. Mr. Keller, whenever you're ready.
Thank you, Your Honor. May it please the court, Scott Keller for the appellants. This case now presents a straightforward First Amendment violation. Maryland's pass-through provision prohibits digital advertising companies from communicating truthful information about lawful prices to their customers in one specific way, through a separate fee, surcharge, or line item on invoices that identifies the tax. Now, the district court correctly recognized this law restricts speech, but the court erred in its facial challenge analysis in ways that the state does not defend here on appeal. Specifically, the district court conflated the pass-through provision with Maryland's general authority to levy taxes, which is not challenged here, and the district court improperly examined circumstances where this challenge provision doesn't apply at all. Now, Maryland does not prohibit companies from raising prices to recoup the tax. It only censors how they may communicate about those lawful price increases. And the Sixth Circuit in Bell South struck down a nearly identical provision, recognizing taxpayers have a First Amendment right to inform customers about government-imposed cost. We submit this as political speech, but we win even if the commercial speech doctrine applies, because Maryland has never articulated a substantial interest, served by its speech ban, much less shown narrow tailoring. So the court should therefore reverse the district court and hold that Maryland's pass-through provision facially violates the First Amendment.
Well, let me ask you this, what kind of speech are we talking about, political or commercial?
We think it's political speech, But just as the Sixth Circuit said, you don't have to resolve that because I do think we win under the commercial speech doctrine. But I do think at this point, who bears political responsibility for a price increase is core political speech, to quote the Sixth Circuit. So I do think strict scrutiny should apply. But again, we don't think that you necessarily need to reach that question because we win under the commercial speech doctrine anyway.
Can you help me a little bit sort of understand why, and sort of accept as a premise that I think the district court got this all wrong, but why we understand fee, surcharge, or line item to refer to something that's put on the bill, right, as opposed to sort of some internal accounting metric, right? When I do the interpretive move, like, help me understand why those are things should be understood as things on the bill as opposed to include things which are in internal accounting metrics.
Sure. A couple responses to the plain text. I think the word directly matters, and I also think the context of what a fee or a surcharge means, and reading these terms as they are grouped together in the statute matters. No one would really think of a surcharge, for instance, as an internal accounting measure. I would say the same as a fee. And I get maybe line item in a different statute, in a different context, not read in context with fee, surcharge, or line item could be that way. But also, I don't think anyone would really say that directly passing on the cost of the tax is just not telling the customer about it and only having internal accounting of it. And I think that's why,
I don't know why that. I mean, you probably have arguments on the, I'm not sure that's at all true. I mean, I'd say directly passing us, here's what you're not allowed to do, right? You're not allowed to say, this tax is going to cost us $5. I mean, actually, you could probably do something even more sophisticated now. You could actually calculate what it's going to cost you on a customer by customer basis and just say, well, they've imposed this new tax on us. What we're going to do is we're going to increase everyone's bill by the marginal amount that the tax, like everyone's bill goes up, and it goes up based on our best estimate of how much more expensive they now are because of this tax. I think that would be directly passing it on, don't you think? Even if you don't tell them. Like, I just raise everyone's price based on my assessment of how much the cost of providing the service to this person has been increased by the existence of the tax. I think that'd probably be direct.
Well, and Judge Heitz, I'm not sure that that's the case under this particular statute, because this statute says you may not directly pass on the cost of the tax by means of.
Oh, no, I was simply reacting to your claiming that the word direct does very much. I think you have a very good argument on the words at the end, which, because the counter argument to the argument I just made is, then I don't know what the words at the end of the statute do. If that's all, if what I said is what it means, then I don't know what the last clause
And it
means.
would be surplusage, yes. So we could come up with what a platonic form of directly passing on the tax is, or line item, but I think the way that the legislature used the terms in this statute is pretty clear, and the state agrees, we agree, that this is all about speech. Now, I take the state's argument to be it's unprotected speech because it's somehow integral to unlawful conduct. This argument's circular, just as the Sixth Circuit pointed out. This chases the state's tail. They're defining the very speech to be exactly what is unlawful. Now, look, if the state had passed a true price control statute, and that may have taken off the table the arguments that we're making here about that this is all about expression about lawful prices. But when they enacted this particular text saying you cannot pass on the cost of the tax by means of a separate fee, surcharge, or line item, we've now crossed into what the Supreme Court in Expression said is protected by the First Amendment. Because this is all about speech, this isn't a price control statute. If I can turn to the argument that this is somehow limited to misleading speech or furthers a government interest in only about misleading speech. This statute's not tailored at all towards that. I don't take the state to
I'm happy to hear from you on this, but if we agree with you that the district court mucked this up, do you think we should do that balancing as an initial matter ourselves, right? I mean, the balancing that you're sort of describing, I totally get, but the district court didn't seem to do, and the parties don't seem to really flesh that out. Is that something that we should do as an initial matter here?
I think you absolutely can, because this statute fails.
I get that we can, What I'm asking is should.
And I think you should for a few different reasons. First of all, this is obviously the second time that this appeal has been to this court, and I think the parties and the district court need guidance on the First Amendment issue. When you look at the statute of this, when you look at the text of this statute, this is a speech restriction. And then you ask yourself, even under the commercial speech doctrine, is this narrowly tailored to further any sufficient governmental interest? And it's not. And the state has not, in their briefs, they have not even tried to identify some interest or a narrowly tailored way of furthering that interest to survive scrutiny. Their argument here is this is just unprotected because it's integral to unlawful conduct. As I mentioned before, that's circular, and the court should reject that argument. At that point, this is facially invalid in all circumstances. There is no way to apply this statute, which is not narrowly tailored, in a constitutional manner. If the state would try to pass some other different statute, like a price control statute, again, that could be a very different situation.
So in terms of what we should do, you heard what I said during the previous argument, and this is the second of two cases where I would say this. I felt like we sent this case back down with instructions to do something, and once again, that thing wasn't done. Because I thought, I know you've got your examples in the brief that are like, these are examples of things that would violate the statute. But I thought one of the things that came up during the previous argument was, sure, but in order to do the balancing that Judge Richardson is talking about, I need to have a sense of the universe of cases where this would or wouldn't apply. Dear district court, dear parties, please provide us a record about those situations. And yet I find myself once again facing a case in which the record was not developed at all.
Well, Judge Heidens, what I can tell you is in looking at what the scope is of this statute, and the district court's errors of looking at the tax. We're not challenging in this First Amendment case the tax. We're challenging this speech restriction. And the district court also looked at unregulated circumstances. And the state does not defend the district court's errors on the facial challenge analysis. And so at this point, I think everyone is in agreement that what this statute covers is speech. If what this statute covers is speech, and it fails even commercial speech doctrine intermediate scrutiny.
Just to go through if we agree with your interpretation of the statute, it doesn't just regulate speech, it regulates literally nothing but speech, right? There's no non-speech applications of this statute because every application of this statute regulates speech.
That's correct. This is a speech restriction, and it's not narrowly tailored. And as soon as it's found not to be narrowly tailored, even under the commercial speech doctrine, it is unlawful in all applications. And so because of that, I don't believe that there's anything additional that the court would need to know to be able to perform that analysis. To contrast this with Moody, and by the way, the district court's facial challenge errors here I think have really nothing to do with the unique First Amendment standard or even Moody. You'd have to properly identify the circumstances that a statute would apply to, even under the traditional no set of circumstances test. For instance, an unregulated circumstance where the act just doesn't have any application, you wouldn't look at that even under a traditional facial challenge. But this is all to say that the court has before it what it needs to review. Is this law facially invalid? It is. It is 100% a speech restriction. It is not narrowly tailored. It is therefore unlawful in all applications.
Can you just walk me through that? What do you take the government interest to be? Right? What is the asserted government interest? Just walk me through how you would consider the sort of merits of this, scrutiny as an initial matter. Because we don't have anything from below, right? But walk me through what you would say. What is the government interest?
What I can point to their brief at page 14, which is saying that there would be some purported interest in prohibiting, this is quoting their brief, prohibiting the taxpayer from structuring the transactions so the consumer is responsible for the tax. Now, the obvious response to that is this law is not regulating prices. Members can raise prices. Members can raise prices to recoup the amount of the tax. Members can raise prices to recoup the amount of tax, and they can tell customers they're doing it in certain ways. It's just they're prohibited from doing it through a fee, surcharge, or line item. And so this provision isn't even furthering that asserted interest in about how a transaction would be structured. As the Sixth Circuit said, this is not something that is trying to get at an illicit transaction. This is all about speech.
So just on the regulating other ways, so I'm going to ask your friend on the other side the same question. Do you understand this statute to prohibit the following? So when I get assuming I'm still getting a physical bill, but when I get my physical bill, there's like a little there's the bill, and then there's like a little blue piece of paper. And that little blue piece of paper says, you may notice that our prices have increased by 10%. That's because the state of Maryland has imposed a 10% digital ad tax on our business. Do you think they could do that?
If it is a separate narrative, say as an insert.
Yeah, it's an insert. Like, dear cluster, you may have noticed that your bill is higher. You may have questions. You may be angry about that. The reason we've done this is because Maryland has imposed a tax.
I don't think that's covered by the act. I think we both.
As in, you think you would be allowed to do that under this act?
I think we would be allowed to do that because it's a separate narrative statement. But I would also say that's an unregulated circumstance, and it wouldn't even factor into what's the coverage of the statute for purposes of the
But
facial
just in terms
analysis.
of, you were saying the fit of like the fact that you don't this is sort of the Sixth Circuit says in Bell South, like if you let someone do that, it's not clear what we're doing here.
We completely agree, Judge Heitens. The fact that you can't say it in the most direct way where you have the attention of the customer that would make the most clear sense, I think that just shows that this is not sufficiently tailored to whatever interest that the state may try to be advancing at this phase in the litigation. Unless the court has any other questions, I would reserve 5 minutes of rebuttal time.
Thank you, sir.
Thank you, Your Honors.
Happy to hear from you, counsel.
Thank you, Your Honors. May it please the court. The pass-through provision of the digital ad tax is not an unconstitutional restriction on speech in violation of the First Amendment. Instead, it regulates speech only to the extent that that speech is integral to unlawful conduct. In other words, because the state may regulate the legal incidence of the tax, in other words, which party is ultimately responsible for paying the tax, because the state may do that, it may regulate the manner, and means through which that conduct is accomplished, even if it has an incidental effect on speech.
So I want to ask you about the unlawful conduct, but it would be sort of I'm having flashbacks to the previous argument in this case. What exactly is the unlawful conduct?
It is structuring the transaction so that the tax is separate from the cost of the services.
That's just a way of saying you can't describe your fees in a certain way.
Right, but it's what we see from Bell South and the district court in this case. Both agreed, both stated that the state can regulate the direct passing through of the tax.
Yeah, you can have a price control. I mean, subject to other restrictions, you can have a price control. But what you can't do is describe how you're going to implement it. You can't, right? But what, I mean this as sincerely as I can. I don't understand. Once you say they can raise their prices, with the express purpose of recapturing all the extra tax money, and they can do that. And if they have sophisticated accounting enough, they can do it like cent to the cent. Once you say they can do that, then I don't understand that how this statute is doing anything other than just regulating how you describe what you're doing, which is speech. I just don't, I mean this as sincerely as I can. I literally don't understand what the unlawful conduct is once you've agreed they can in fact raise their prices because of this tax.
Right, well, one point of agreement that I have with my friends on the other side is that the direct part of it does some work in this case, obviously in conjunction with the fee surcharge and line item, in terms of saying that whatever you do internal facing is not covered by this statute. But the direct passing on happens.
There's at least one thing you can do external facing. You can raise your prices, right? No one disagrees that under this statute you can in fact raise your prices.
You can raise your prices, and you can include an insert that explains why you're raising your prices. And it doesn't even have to be a separate insert. It can be on the bill. It could be a phone call. It could be any sort of speech.
Like at the end, it'll say, like, dear customer, you may notice your bill is higher this month. The reason is because those people in Annapolis have enacted a tax, and now things are more expensive. Sorry. They can just say that, right?
They can say that as long as they don't structure the transaction so that there's the cost of services and then the tax being imposed separately from the cost of services. And that's what this law does.
Can you explain to me what the government's interest is here? Right, so just because you're raising it now, I get I'm out of order, and my question assumes that you have lost, right? But just bear with me for a minute. Like, what in the world is Maryland's like legitimate government interest in saying that you can add the paragraph at the bottom, but you can't have the like little indication surcharge for digital tax $7? Like, what is the government's interest here? If I'm doing the First Amendment balancing today, I'm going to sit down and write it out. What do you assert the government's interest to be?
In making sure that the company, that the taxpayer is being responsible for the tax. And
No,
that's
that's gibberish, right? Because you've just said that you're not doing that. That they can absolutely pass 100% on to the customer. And they can tell them that that's what they're doing, right? So you can't say that your interest is to ensure that the taxpayer's paying it and not the customer. Like that doesn't make any sense.
But it requires that the taxpayer do that extra step of adding that tax in. And what we see in the record, it may not be in the briefing in this case, it's in the briefing from before when the Tax Injunction Act issue was more at the forefront. But it discussed the economic theory behind regulating the tax incidence vis-a-vis the taxpayer or the customer. And it said when you regulate the tax incidence and when you make the taxpayer be responsible for the tax, that yes, maybe they will pass it through, but oftentimes they won't. And it depends on a complicated, as economics is, factor of how much the tax is, the flexibility of the price, the elasticity of the product, and all those economic factors so that.
So that's, I take that argument to be that when you prohibit them from being transparent, they might not do what you don't want them to do? Is that, I mean, the idea is like, if they can be transparent about what they're doing, they would do it. But if we force them to not like be transparent about what's happening, then they might not want to take the hit from raising their
They can absolutely be transparent about why they're raising prices.
No,
And-
but they can't put the surcharge on there, right? Like, that's what, they can't have the line. Like, that's what's transparent, right? Like, you're like, yeah, if you put this at page 7 of the notice, right, that's fine. But they can't, like, transparently show it. And your point is, so your argument, I didn't get that before, but your argument really is that the government's interest is in prohibiting truthful information to be conveyed. Like, that's what you think the government's interest is.
That's not the government's interest at all. The government has passed a law that says that this transaction can't be structured. You can't directly pass on this tax through a separate line item, fee, or surcharge. And that's what Bell South said was conduct.
But you can pass it on. You just can't pass it on in a particular way, right? Because we agree. It seems to be agreement. It seemed to be the agreement in the previous argument. They can, in fact, pass on. They just can't pass it on in way 1 that looks like speech, and way 2 that looks like speech, and in way 3 that looks like speech.
But all along, we've conceded that it's speech, but it's speech that furthers this transaction. As we laid out in our brief, there are cases that describe speech. I mean, it's an exception to the First Amendment where, for example, we have cases about child solicitation, which is a crime. And it's a crime that's accomplished through words and through communications. And it's the same principle at play here. In order to directly pass on the tax, you need to communicate that fact.
That's because 2 people teaming up to kill someone is a crime, and the fact that they do it in words doesn't mean it's not a crime to team up to kill someone. But to continue the analogy here, it is in fact legal to pass on I just don't. Again, I will raise it the one last time. I just genuinely, once you concede they can pass it on, I don't understand how this is suppressing speech about illegal conduct.
Because that's internal facing, but external facing, the state can regulate the tax incidence or legal incidence of the tax, meaning that they can say that the taxpayer needs to be responsible for this tax. I'll point you to.
But they haven't said that. I thought you just conceded they haven't said that. They haven't said the taxpayer has to be responsible. They've said you can pass it on. Like, you can pass it on. You don't have to be responsible. You just can't be honest about it. Like, literally, it's like you just can't be honest about it. If you're honest about it, that's bad.
Well, what would happen if these people had put their costs, the regular charges, then they put the amount of the tax, they put an asterisk by it, and down below, put an explanation. We are being taxed, and we're paying it, but it's a cost of our doing business, so you've got to pay it back to us. What would be wrong with that?
Well, if the question is, would that violate the statute? Yes.
Okay, and how does that not violate the First Amendment?
Because the state is regulating the legal incidence of the tax. That is conduct. That's what Bell South said. That's what the Sixth Circuit said in Bell South. District Court agreed in this case. And that is the total premise of Bell South. This case is not Bell South.
Well, back to Judge Richardson's question a while ago. Where is the governmental interest in that? That they're honestly showing the tax that they pay, what they're going to recoup from their customer. What is the government interest? I'm having trouble with that.
I understand. Thank you for letting me know that. But the interest is in making the taxpayer responsible for the tax. As Bell South said, as the district court said.
Do you want to put the word politically responsible in front of that? Is what you're saying the government's interest is that we want to make the taxpayer politically responsible for it? Or do you mean like financially responsible?
Financially, actually.
Because it seems like what you're saying is you want to make them politically responsible. Like, I think what you're really telling us is that Maryland's interest is making them politically responsible, because we know they don't have to be financially responsible.
But if you wanted to see an example of what politically responsible or trying to make the taxpayer politically responsible, you'd look at Bell South. Bell South is very relevant to this case. I believe it helps our side more than the other, and it does that because the statute at issue in that case, it regulated directly passing on the tax, and it prohibited separately stating the tax on the bill. Couldn't say anything. Couldn't say that you loved the tax, that you hated the tax, that you imposed the tax, that you passed on half the tax, quarter of the tax, whatever. Couldn't say anything. And we don't have that. As the state has conceded, as other side has conceded, you can put on the bill the political responsibility for the tax. You can explain that they are putting this tax, that they are imposing this tax, or that services have been raised.
That response is to say that we can ban their truthful speech because there's another avenue for them. They could speak in a different way, right? So that doctrine, that seems like what the district court some to believe. Can you point me to where in case law we've said that you can bar political speech because there's another avenue of making political speech? I mean, we don't typically do that. Like, we don't say you can't hand out pamphlets because you can stand up on a soapbox. Like that argument, which I think is the one you're making here, is the one the district court accepted, seems unusual to me.
That's not the argument at the forefront. That's the argument that explains or responds to the argument, why are you preventing people from talking about this tax on the bill? And the answer is, we're not.
We're only preventing them from doing what's most clear and transparent. We'll let you do it so long as it's not clear and transparent. That's the government's interest.
The government's interest is that there be a separate price for services, or a price of services, and that be the cost that is imposed on the customer, and that you can't then have a separate statement that says we're going to charge you $1,000 for services and $100 for this tax. The taxpayer, under the law, the taxpayer is responsible for the tax.
Politically responsible.
Actually responsible. Financially, they have to shell out the money for it. So I'm having difficulty understanding why that's political.
Because you agree, if they say in your example, if they say $1,000 for services and $100 for the digital tax, right? You think that is impermissible.
Prohibited by the statute.
Right, prohibited by the statute. But if they said $1,100 as the cost, and everybody understands that $100 of that is for the digital tax, and then at the end of the statement, they explain there's 100, your prices are higher, right? We've had to increase prices by 10% because Maryland has imposed this digital tax. And so when you look at that number, you should understand it in that light. That'd be permissible.
Yes.
Yes, okay. And so just one more time, and then I'll let you talk about anything else you want to. Can you just, as concisely as you can, explain to me what Maryland's interest is in that?
Could you explain
And
that?
you can say the one thing Judge Richardson just said can say, but you can't say the thing that saying, I can do it, $1,100, you may note that it's higher, that's okay. You can't say $1,000 plus $100 equals $1,100. What is the possible interest in allowing you to say the latter but not allowing you to say the former?
Well, the interest in the former, which is structuring the tax, or structuring it so it's $1,000 and $100, the interest in there is prohibiting the tax incidence, prohibiting the taxpayer from passing on that tax directly to the consumer. The interest in not prohibiting the taxpayer's ability to speak about the tax is complying with the First Amendment. Because unlike in Bell South, we would agree is a violation of the First Amendment because by prohibiting separately stating the tax, Kentucky prohibited any speech about the tax, positive, negative, however, and it went outside of what the Sixth Circuit deemed was permissible conduct, which was regulating the legal incidence of the tax.
Do you agree that the purported government interest that you've provided is the only government interest? Like, there's no reason, if that's the interest, there's no factual development of that that's required. Is there any reason we shouldn't address that government interest here? As being like wholly legitimate or wholly illegitimate, right? Is there any reason, I just want to make sure from Maryland's perspective, is there any development of that that's necessary? You seem to say it pretty clearly. Is there any like factual development that's necessary to understand that interest?
Well, my response is I think where the territory that you're in is in the strict scrutiny and the intermediate scrutiny space, where we do some interest balancing and we look at the government's interest and say, is it good enough? Is it developed enough? And the state's position is that we don't go to that territory because this is conduct.
I totally understand that. Except for a hypothetical minute that like you lose on that argument and instead we're asking you about the government's interest, right, at the First Amendment analysis because we think this is a regulation of speech. Is there any factual development of the government interest that has not already been done? Right? Is there like a, is there a record below that you've got an expert that you want to testify, or is this sort of, I mean, it's a legal argument. These are legislative facts. I get all that. It's not adjudicative facts. Is there anything that we should look at to substantiate that that you haven't provided in the briefs already?
I think I would just point to the extent that it's sort of extra or outside the record of this appeal that we're here for today, is to look at the record in this case as a whole. And you'll see
what
that.
in particular? Can you just suggest what I would look at? I understand you talked about the TIA and the language about the sort of the economic piece. I'll look at that. Is there anything else in the record specifically that you would want me to look at in evaluating the government's interest here?
Your Honor, I can't think of anything. I think that's.
I just wanted to give you that opportunity, that's all.
And I appreciate that.
Let me make it simple. Suppose you're writing the opinion, and we're gonna put a paragraph or a sentence in there. The following is the governmental interest that we are upholding. What is that?
It is.
What would you say?
Again, it's the government is regulating the legal incidence of the tax. They believe that the taxpayer should be responsible for paying this tax, and that the taxpayer should not be allowed to pass on this tax directly to the consumer.
How is that not form over substance, or vice versa?
I would point you to the discussion that I just had with Judge Richardson about the economic theory and putting that in. And to give you a concrete example, I'll point you to the Nelson v. Appleway case, which was out of the Supreme Court of Washington, cited in our brief. And in that case, as a practical matter, it was a car dealership. They negotiated a price for the car with the customer, and then lo and behold, when the customer comes in to pay that price, they have the business and occupations tax that they have now put on top of that. And there was a Washington law that said that the car dealership could not impose the B&O tax on the customer. And so that was a very concrete example of where they were regulating the legal incidence of the tax. They found that that was improper conduct, and that it certainly, and also, for whatever it was worth, it was not a First Amendment violation to preclude the car dealership from structuring the transaction in that manner. And so the extent that this court needs one, that would certainly be a constitutional application of this tax, where the parties have negotiated a price for services, and then when it's all said and done and it's time to pay up, that the customer comes in and now the taxpayer imposes that digital ad tax on top of that in contravention of the statute. And so if there's no further questions?
Thank you, counsel.
Thank you.
Mr. Keller, we're happy to hear from you.
Thank you, Your Honor. 3 quick points. I'll touch on the merits of the First Amendment, the Nelson case that was just discussed, and then the facial challenge standard. But first of all, at this point, it's conceded that this law is all about speech. This is not a price control statute. We can pass on the tax. And at that point, I think it gives up the game, and we win under the Expression Supreme Court case. I mean, basically every argument you've heard about trying to structure the transaction this way or that way, Expression said, when you're talking about communications about lawful prices, that speech in the First Amendment applies. And to turn to Bell South, I think Bell South absolutely helps us. Not only did it invalidate the separately stating position, but I'd like to quote what the Sixth Circuit said on this issue about switching the legal incidence of the tax. This is at 542 F3rd at 503. What the Sixth Circuit said is, if you were going to try to switch the legal incidence of the tax, it'd be one thing if the taxpayer was telling a customer, quote, this is your legal responsibility, not ours, customer. But that's not at all what's going on, and that's not at all what this law regulates. Here, what companies would be saying is, here's the final price, and here's the amount we're raising the price to recoup this tax. That's not switching the legal incidence of the tax. That is passing on the tax as the state has conceded we can. And this law is not tailored to whatever interest, and I know there was a long colloquy about whatever the interest could be that the government has. This law is not tailored to that. What it does is it restricts speech. It bans surcharges, and we know from Expressions the First Amendment does not allow that. If I can very briefly address the Nelson case from the Washington Supreme Court, it's quite distinguishable. There, to quote the Washington Supreme Court, this is 157 P3rd at 851, quote, Appleway, one of the parties, may itemize the tax if it is part of the final purchase price, unquote. That's exactly what we have here. That's the exact scope of what's going on when there's a surcharge next to a price. In that case, the Nelson case, that was about you go in to buy a used car and you negotiate a price. You come to a price, say $10,000 for the car, and then a couple hours later they come back with all the paperwork and they say, here's the sales tax, and oh, by the way,
The check you need to write me is now $11,000.
here's the B&O, and it's more. That's not at all what we're talking about here. This law is regulating the surcharge right next to the final price. And then finally, on the facial challenge standard, just to make sure, this law in this situation is unlike the Moody Supreme Court situation. This law is narrow. At this point, we're talking about it only applies to the largest digital ad service providers. It's talking about surcharges, fees, line items on a specific invoice. This is not at all talking about, what is the full scope of what a potential digital service like Uber or email or anything could look like, or billions of posts on social media. And so this court doesn't need any more facts. The state has never said that it's needed more facts. You just heard from the state it doesn't need more facts. And also, too, the Expressions case from the Supreme Court did not need additional facts. This law...
Suppose, I don't mean to disturb the conversation, but suppose we severed that provision, would the rest of it survive a constitutional challenge?
I don't think it would. I also don't think that you can sever it because I think it would contravene the legislature's intent here. You know, severance would go to, would the legislature have passed a different law without this? I mean, here, by means of is limiting language. Now, even if we are, Judge Floyd, in the realm of severing, I think you'd first have to say the First Amendment applies, there is a First Amendment violation, and therefore we're creating a remedy. I also think, I'm not sure then what directly pass on the cost of the tax means. I mean, we could still indirectly pass that cost on.
I don't necessarily disagree with you, I just want to know, what do you thought?
And that's our answer. I do think that this violates the First Amendment in multiple ways, under expressions, under Bell South. The government doesn't have a sufficient interest. Even if it did, this is not properly tailored under either the commercial speech doctrine or the political speech doctrine. Thank you, Your Honors.
We'll come down to Greek Council. And then we'll proceed to our next. .45 Plyler versus Cox. Mr. Robb, please don't hurry, but whenever you're ready and your opposing counsel's ready, we'll be happy to hear from you. Thank you.
May it please the court. This case highlights the harm that can result when a district court disregards its Daubert gatekeeping obligations to ascertain that expert witness testimony is both relevant and reliable before it is submitted to the jury. The district court in this case expressly refused to make those determinations, instead ruling that it was the jury's job to do so. And as a result, expert testimony was admitted that, among other things, was relied upon by the court in denying the defendant appellant's Rule 50B motion, which testimony should have been excluded. When that improperly admitted expert testimony is disregarded, the evidence at trial did not provide a legally sufficient evidentiary basis for a reasonable jury to find for the plaintiff on last clear chance and on gross negligence.
But is that how we do it? Wait, so you want us to hypothesize that you win your Daubert challenge, we then knock out that witness, and then you think we would proceed to ask whether they're a case absent that witness? Because it would seem to me, if I was a plaintiff and lost a Daubert motion, I might try to find another expert, as opposed to just be like, well, I guess I don't have an expert now.
Well, Your Honor, that's exactly what this court did in Nice and in Sardis. On the appeal, following the denial of a Rule 50B motion, the court first ascertained whether expert witness testimony that had been admitted was properly admitted. And in both cases, the court found no, that evidence was inadmissible. It should have been rejected. After that inadmissible evidence was rejected, the court then performed the Rule 50B analysis, excluding that inadmissible expert witness testimony, and determined that the remaining record was insufficient, legally insufficient, for a reasonable jury to find for the plaintiff, And consequently, in both those cases, the court did exactly what we're asking the court to do here, which is to remand the case to the district court for the entry of judgment in favor of the defendant.
Well, let's assume that we agree that the judge was right. Then talk about why the jury could not come to the conclusion as it did that the last clear chance doctrine applied, therefore the plaintiff can recover.
Certainly, Your Honor. So the expert witness testimony that we contend was improperly admitted.
I'll give you that, but I mean, just let's
Sure.
assume we don't agree with you.
Sure. So when you get to last clear chance, the evidence at trial did not support a finding of last clear chance under either of the two theories of that doctrine that are recognized in North Carolina.
And what case says that?
What
What I see you cite, you insist the restatement of torts says there are two theories of last clear chance, and you say North Carolina has adopted that. And then I look at the authority that you identify for that proposition. Problem number one, it's a decision of the North Carolina Court of Appeals, which is not the Supreme Court of North Carolina. And two, it doesn't say that. It just cites this provision of the restatement, which is different than saying in North Carolina there are two and only two theories of last clear chance. So what authority, other than the Court of Appeals opinion that I do not believe adopts that rule, do you think says that?
Well, certainly, Your Honor. So you're referring to the Keenan versus Bass case, which goes through the law of last clear chance in North Carolina and restates both portions of the restatement of tort. We've also got the Cagle opinion of this court, which looked at the question of last clear chance in North Carolina and also evaluated the portions of the restatement of torts, that you've got the helpless plaintiff theory
I guess what I'm
of
not
last clear
clearing
chance.
is that the highest expositor of North Carolina law has said these are the two and only two versions of last clear chance that exist in North Carolina.
Well, Your Honor, what the highest version of North Carolina, and Your Honor, the specific name of the case escapes me at the moment, but it's cited right at the beginning of the discussion of last clear chance in our opening brief, North Carolina Supreme Court case. And what the court said was that when you look at last clear chance, it's very factually specific, that you need to look at the specific facts, and the court goes through the analysis of both 479 and 480 of the restatement second of torts.
Can I just start with a premise? Judge Whitney's a very good judge, and so you make some interesting arguments on appeal. One of the challenges I've got is that I don't see any of those being made below. None of this discussion goes on. It doesn't appear to me that you object to the jury instruction on last clear chance. And when I look at the half-hearted arguments that are made below, they're just conclusory, right? So you got a trial brief that has a paragraph that says you just can't possibly find this, right? At the conclusion of evidence at J1628, you say there's just no evidence of last clear chance, which is a great conclusion, but doesn't give Judge Whitney much to work with. And then after the trial at 1872, you just say the same thing, right? Am I missing where you put the district judge on notice that it needed to do something beyond the jury, right? Because when I read the arguments that you made below, Judge Whitney's decision seems like not just reasonable, but patently correct. When I read your argument, to your great credit, on appeal, you make some fairly persuasive arguments, but it feels an awful lot like a sandbag where you're asking us to reverse Judge Whitney when you accepted the jury instructions as they were and made no effort to sort of distinguish these two ideas or, go down the road of explaining when he was in peril, at what moment that existed, what was supposed to happen. None of that was given to Judge Whitney. It's all given to us now, quite well done. Kudos to you for writing a good brief. But what am I supposed to do with that when I got a district court judge who's doing an excellent job across the board? You make some sort of passing reference to the last clear chance doctrine, and then now expect us to trace through the various strands of the restatement that you don't raise or address and cases that you don't cite. Well, what am I supposed to do with that?
Well, Your Honor, I disagree with the statement that this was not raised at trial. In the context of the trial, the discussion was focused on whether or not Mr. Plyler was in a position of helpless peril and whether or not the defendants had the last clear chance to prevent his injury. And so at the trial court briefing, at the trial court argument on the Rule 50A motion, the focus was principally on whether or not the defendants ever had a last clear chance to prevent Mr. Plyler's injury. And we pointed to the evidence that did not support that argument. The fact that at the time that Mr. Plyler was hurt, nobody else was anywhere near him, that Mr. Plyler is the one who opened the sliding steel door, and there was no evidence that anybody else in the bin was aware that he had done so. And we did object to the trial court submitting the issue of last clear chance to the jury. And so the issue is not so much with the way that the jury instruction was couched, but with the submission of that issue to the jury in the first instance.
You never asked the trial judge to tell the jury in North Carolina there are two and only two theories of last clear chance because the restatement of torts says that, right?
That's correct, Your Honor, because...
So you have to, and that you never asked the trial judge to tell the jury in order to find last clear chance, you have to make the findings in this provision of the restatement or these findings in this provision of the restatement. You never told the trial judge he should tell the jury that.
No, Your Honor, but with respect, there was no reason to do that because the plaintiffs at the time were arguing helplessness. They were not arguing inattention. They were not conceding Mr. Plyler obviously wasn't paying attention to what he was doing, but you can find last clear chance anyway. They were focused on helplessness. And so our response was to helplessness. But when in the 50B briefing, the plaintiffs began to argue inattention, at that point, in our reply brief, we raised the issue with the judge and articulated the distinction between helpless plaintiff and inattentive plaintiff. And so Judge Whitney had all that information in front of him when he ruled on the Rule 50B motion. And respectfully, Your Honor, the standard for your consideration of this Rule 50B motion is de novo. You're looking at whether or not Judge Whitney made a decision that was legally correct as a matter of law.
Well,
and
no,
so
our standard is de novo for arguments that were properly preserved in the district court, right? Our standard is not de novo for arguments that were forfeited in the district court.
And that's always the case, Your Honor, and I do believe that we properly preserved this here, where when the plaintiffs raised the issue of inattention really for the first time, if you look at the trial record, nobody was arguing Mr. Plyler was admittedly inattentive, but we can recover on last clear chance anyway. That was raised in the post-trial briefing, and it was responded to appropriately in the post-trial briefing at that time.
Do you think you can, like, do that? I don't have the post-trial briefing before me, but when I look at all the arguments that you made in the pretrial brief, after the close of the plaintiff's case, and at the end of the trial, none of those seem to make those arguments? Like, can you then show back up? I mean, it feels to me like you've sandbagged the district judge. I don't mean that as a critique. I'm just saying, like, these are very superficial arguments that are being made to Judge Whitney during the trial, and then you come up here and give us all of these cases and things that you didn't give to the district court judge. That just feels to me like you've forfeited the nuance, right? That what we ought to be doing is saying, like, the arguments that you've actually made are the ones that are in the briefing and in the hearings, and to the extent you've got new arguments about theories of this doctrine or cases that sort of articulate when peril attaches, right, which is totally a fascinating set of your brief, right? I thought you did an excellent job of articulating it, right? But when I look at the briefing in the district court, like, there's no discussion about when peril attaches. In fact, that's why the jury asked the question, but goodness sakes, how are we supposed to know when peril attaches, right? Is it when the grain bin is built? Is it when he's called? Or is it when he enters the bin? None of those issues had been addressed by you or by the plaintiff, frankly, but they got an instruction. They'd make the best decision. It's hard for me to, like, critique Judge Whitney, even though I think you've got some really good arguments on appeal.
Well, and Your Honor, I think you made the key point there, or by the plaintiff. we raised legitimate objections, objections that still hold, and that if Your Honor merely considered the question of whether anybody else in the bin had the opportunity to prevent his injury, we should still prevail. But we responded when other arguments were raised in an appropriate fashion. I don't think it was incumbent on us to raise every single possible reason why Judge Whitney should not have given a last clear chance
You
instruction.
don't have to raise every reason, but if you don't raise a reason, you can't raise it now.
Well, we did raise it, Your Honor.
That's the rub.
In the
wait, can I-
post-trial briefing, we raised all the arguments that are raised now. They were raised to the district court before the court entered the order that we've appealed from. We raised them at a time when they were responsive to arguments that the plaintiffs had asserted. And so I'd contend, Your Honor, that we have properly preserved, but more to the point.
Can you just make sure I understand, is this 1872? Is that where JA 1872? Where is the briefing that you think has raised all the arguments that are in your brief?
It was the reply brief that was filed in support of our Rule 50B motion and motion for a new trial. It was filed approximately January 16th of 2024. I don't know the joint appendix reference.
January of 2024 or January of 2025?
It was filed in January of 2024, Your Honor. Our trial was in November of 23, and we had our post-trial briefing in December and January. So it was filed in January. That reply brief went in great detail into the last clear chance arguments that we've asserted here, and I believe that it was appropriate to do so at that time because it was responsive to arguments the plaintiffs made.
So what you want to say, because when I read the actual motion that you made, about the extent of the argument is there is no legally sufficient evidentiary basis from which a reasonable jury could have found last clear chance. That's like that's it. I mean, I just quoted the whole argument that you made on last clear chance in the opening brief, and your position is that you didn't raise it in the initial brief, you didn't raise it before the trial court in argument before that, but in the reply to the Rule 50B motion, that's how you preserved all these arguments? Like that's where you want me to look to say that you've preserved all the arguments about when peril attacks and the like.
I do think that that's an appropriate place to preserve the arguments because they were responsive to specific arguments that the plaintiffs raised to counter our brief, to counter our motion.
Well, can I ask you about another response
Yes,
point?
Your Honor.
So in your opening brief before us, you say that the owners of this business can't be held liable because they weren't there. And then in their response brief to your opening brief, they quote cases for the seemingly uncontestable proposition of if you are a general partner in a partnership, you are liable if the partnership is liable. And then I notice in your reply brief, you don't mention the two owners of the business. Do you have any response to the argument
Yes.
that if the business is liable, the owners, I understand there's two people who aren't owners. I want to bracket the people who aren't owners. But in response to the argument that they make in their response brief that you conspicuously do not respond to in your reply brief, if the business is liable, the general partners are also liable. It doesn't matter if they were there or not. What part of being a general partner do you not understand?
Well, Your Honor, I do understand what it means to be a general partner, and they would be liable as general partners, but that argument was raised in the context of last clear chance. The question of whether they personally were present such that they individually had the last clear chance to prevent Mr. Plowell's injury. And there's no evidence to support that, Your Honor. So no, we're not contending.
Okay, but let me go to their theory. Their theory is that if an agent of the business was there and had a chance, then the business is liable under respondeat superior. And once the business is liable, the owners of the business are personally liable because that is one of the most essential characteristics of being a general partner.
Right, and I don't disagree with that, Your Honor, but the argument was made in the context of whether or not these individual owners had the last clear chance to prevent Mr. Plowell's injury. That argument was not really responsive to that issue. So I don't disagree with what you just said. I believe that's a correct statement of the law, but they weren't physically present. They didn't have the last clear chance. I seem to be almost out of time. I just want to briefly address the cross appeal. This is addressed, I think, extensively in the briefs, but I just want to make 2 points. First, the plaintiff's argument about what the standard should be is really an outlaw argument. They're not arguing as to what North Carolina law is. They're arguing as to what North Carolina really ought to be, because the plaintiff's rule is completely inconsistent with the Court of Appeals decisions from the 1980s in Assolino and Paris and Schenck. Finally, the plaintiff's argument comes from, I see that I'm out of time, Your Honor. May I finish my statement?
You can finish this thought, yep.
Yeah. The plaintiff's argument really relies on the Searley case. The Searley case is an unpublished Court of Appeals opinion which is not authoritative in the state of North Carolina as an unpublished opinion. And moreover, as the plaintiffs themselves raise in a footnote in their reply brief, when two lines of authority at the Court of Appeals disagree, you go with the older one. Well, the older line of authority is what we have cited from the 1980s as opposed to the Searley case, which is from 2005. Thank you, Your Honor.
Happy to hear from you, counsel.
Good morning, Your Honors, and may it please the Court. Alex Heroy on behalf of the plaintiff, appellees, and cross appellants, Robbie and Debbie Plyler, who are also here in the courtroom on the first row behind me. Thank you for hearing us today. This case is about the plaintiff, the appellant's attempt to say that Judge Whitney got all this wrong and the jury got it wrong, when we have a unique circumstance that we know the jury was specifically attuned to the issues on which they appeal. They were attuned to the issues of when does last clear chance attach? Do the facts support last clear chance? And so I think it's a high burden, not only on our procedural history, but on the facts of this case. I'll turn also to Judge Hyten's your question about where does it say North Carolina observes this dichotomy of inattentive plaintiff versus helpless plaintiff. I don't believe that's the law. I believe that the North Carolina Supreme Court in the Exum case from, I think it's 1958 approximately, does cite the restatements, but they say our law is this and goes through the elements which Judge Whitney properly gave in the jury instructions to the jury based on those factors, which the appellants agreed to the form of those jury instructions, and says these are the elements of North Carolina law. It's also in accord with the restatement and says that it supports it too. And here's the different theories that are just advanced nationally. It even goes back to a case in England called the fettered ass case and says this is where it goes through. So it's a historical context of where that comes into play, and it supports the last clear chance. So I think the case is, the law was correctly submitted to the jury focused on it and got it right. If we're going to go into this sort of hyper-technical, when does the peril attach, I think it's very clear that the jury could reasonably find that the appellants were negligent when they cut the bar out, when they didn't provide training, when they didn't tell people. And then Mr. Plyler was negligent when he opened the doors all the way. And that was certainly a theory below.
And so what I know, I guess, from the jury, what I know from the verdict form is that the jury found that the plaintiff was contributory negligent in at least some way. Well, we know that. But so what you're telling us, though, is I don't know from the verdict form what exactly that the jury found he did that was contributory negligent.
Correct.
And so in order to, and I meant to ask the other side of this, but just when we say last clear chance, am I right in thinking what that really means is that after the plaintiff's negligence was over, there was an opportunity for the defendant to prevent it from happening? Like,
No. And the
around the same. Go ahead.
No, the Exum case for the North Carolina Supreme Court specifically disavows the logic that it has to be a subsequent act of negligence by the defendant, subsequent to the plaintiff's act of contributory negligence.
Because they could be simultaneous?
Or the plaintiff's negligence can be ongoing, as this court observed in the Cagle versus Baltimore Railroad case, where the man's on the tractor and the train's bearing down on him.
Sorry, I mean simultaneous in the sense of the plaintiff is doing a course of conduct that is just negligent.
Correct.
And at some point after the plaintiff has started his course of negligent conduct that continues right up until the moment he's injured, the defendant has an opportunity to stop the bad thing from happening.
Yeah.
After the plaintiff started doing the negligent thing?
Yes, I would quibble with it a little bit, just because under Exum it says that the defendant's negligence can be ongoing. It doesn't have to be a subsequent act, and they specifically disavow that logic in the Mathis
Two
case.
vehicles are going towards a wire, and honestly, neither person is paying enough attention to the fact that there's a wire? Is that the case you're talking about?
The Exum case is it's the.
I just remember one of the North Carolina cases, a case about two people going along, and there's a wire, and like they both should be looking for the wire. And the defendant's argument is the plaintiff should have been looking for the wire, and then the plaintiff's argument is, but you should have been looking for the wire too.
Yeah, that's the Keenan versus Bass
Okay,
case. The Exum case is where there's the man changing the tire on the side of the road in Chapel Hill, and he's got his back towards the traffic behind him, and then the defendant is kind of barreling in and should have seen him changing the tire and did not. And the court said, well, you could have just whipped over to the side. And so your duty is ongoing. Yes, you were negligent, defendant was negligent and did not see the plaintiff changing the tire, but then continued to be negligent, and the North Carolina law imposes a duty on people, on drivers, to have a constant vigilance to the roadway and see that. And so the defendant had a constant duty to see this.
Just to make sure I understand, I think I understand the argument you're making, but so the defendant's action has to be at least occurring, whether it started before or after, at least to be occurring at some point after the contributory negligence began.
Correct.
Right, so
it's approximate cause analysis.
So
correct.
what we couldn't say here, to go back to the jury's note, is that in the last clear chance was in cutting out the bar.
Correct.
Right, so,
Correct.
okay. But the last clear chance in this scenario, as you posited it, has to come inside the bin on the day of the incident.
I guess it could come just before that, when Mr. Plyler opens the doors and he's about to get in, and they see him
Okay,
about to get
I'm
in.
not trying
So
to-
quibbling with it a
Right.
tiny bit, but yes, it's after that.
So just in terms of concretely what could have happened, at some point someone could have said, hey, don't do that. That would be a bad thing for you to do. Or hey, just keep in mind that when you do that, there's this thing that would be really dangerous to you.
Hey, we cut the bar out. Yeah, they could have done this, could have done lots of things, and they didn't. And that's when they had the last clear chance. There's a lot of time. Mr. Plyler testified he had an entire conversation with Mr. Phillips, one of the managers, inside the grain bin, and nobody said, hey, we cut that bar out, and you can't see it in here. It's very dark, it's very dusty, and even as we submitted, and there's an OSHA regulation or letter of interpretation that talks about that.
What's the best evidence that someone inside the bin not just knew that he was there, but knew that he was in some form of like helpless peril, right? And I'm not trying to distinguish between the two types of thing, but they both involve some sort of peril that he's in, that he's not capable in some sense of extricating himself from. Like, what's the best evidence, taking it in the light most favorable to you and those things, that would help show that there's evidence that a jury could conclude that somebody in the bin sort of looked at Mr. Plyler, who's not some newbie, and sort of recognized or should have recognized that he was in helpless peril?
That's a good question. I think it's heavily fact dependent. And Mr. Plyler, his testimony is, I went in, I did not know the bars had been cut out.
Yeah.
I go in the bin, I have this discussion with Mr. Phillips. And no point during that time, Mr. Phillips admits he has superior knowledge. He knows the bars were cut out, and the jury can believe.
What's the evidence that he knew he had superior knowledge? He knew the bars were cut out, but what's the evidence that he had any reason to think that Mr. Plyler did not know that?
You're right.
Right, like,
You're right.
superior knowledge, I mean, I totally get it. If he had superior knowledge and knew that, that's one thing. But we don't really have that, right?
You're right, and I misspoke, and he has superior knowledge, and he knows the bars are cut out. Robbie does not. His knowledge is superior, but he doesn't go so far to say, I knew that Robbie did not know, which I think is what you're
Right.
getting at.
Yep.
And so, well, we do know that many people on the farm were not told the bars were cut out. And so then you look at, did he know, should have known, or have a duty to Mr. Plyler under the case law that we've all submitted? And I think under all of those, he should have known because lots of people on the farm did not know. This was not Mr. Plyler's normal operation. There was no warning whatsoever. There was not training on this farm, so he should have known, the jury could find, or that there was a duty to ensure these
That's like
things.
a little hard, right? Because, you know, you read the trial transcript here, to Mr. Plyler's great credit, he was sort of extraordinarily well-respected, it seems like, just from the trial record. And so it seems a little odd. I mean, that's both positive for him, but it sort of undercuts this idea that somebody in the bin should have been like, I'll bet that guy has no idea what he's doing here, right?
You're right, but I think that's a determination for the jury. That's a credibility determination. Mr. Plyler said, I'm normally on the hog farm. I'm doing maintenance. I'm the maintenance man. I've done grain bin cleanouts, but it is not my normal gig. Whereas everybody else is doing it multiple times a year. And so everybody should know that Mr. Plyler, this is not something he does every day, and you got to be extra careful. He's not trained on it. He's in inferior position because he doesn't do it all the time. And so I think that the farm has a duty to make sure that everybody knows, you go into the bin, we've cut these bars out, because that's not part of his normal operation. So I think that, again, that's a question for the jury, and I think the jury we know the jury was attuned to this issue. They looked at it. They said, when does it apply? And then Judge Whitney correctly, over no objection, restated the law in North Carolina from the jury instructions, or provided to him. I don't actually think he restated it. He provided to him.
What do you do with the idea that we know from the question that they were plainly confused about when peril attached, right? I mean, I think you would agree that 2 of the 3 options they give, like, if we were doing just pure law, would have been incorrect, right? Like, the peril did not attach when they built the grain bin, and peril did not attach when the phone call came in. I mean, I don't take you to be arguing that it could have, right? That only one of the 3 options that were available, but sort of suggests that they didn't quite grasp what was going on here.
I agree with you. I mean, I think that certainly it didn't attach when they built the bins. I think when Mr. Rusty Cox tells Mr. Plyler to go to the bin, that's a maybe, and I'll tell you why, and in all candor, I admit that's tenuous. But then certainly once Mr. Plyler goes into the bin and opens the doors, I think it's very clear. So one, we'd have to assume the jury got it wrong in saying, well, we've got 1 of 3 or maybe 2 of 3, and we're just going to assume they went with, installation of the bins and they got it wrong. I don't think that's what you guys would be doing. And then, to get into a little bit more creative argument on the Mr. Cox phone call to Robbie, if the North Carolina Supreme Court cites this unfettered ass case, and I get it's a weird case from England, but the North Carolina Supreme Court cites it, and in that case, you've got a man who fetters his donkey, which ties it up and makes it so it can't escape, on the roadway. And then you've got another man who's coming along the roadway with his horses, and he's behind the horses and he can't really see them. So he's let, in modern day terms, his agents or something like that go ahead of him. And they say last clear chance applied because he should have been up there with his horses. And his horses ran over the donkey and hurt the donkey or killed the donkey. And so the last clear chance applied when he should have been, his duty was to be with those horses, and had he discharged that duty, he could have had the last clear chance. So the jury, it could be that Mr. Cox, has a duty to ensure the safety inside the grain bin once he's sent somebody there. Once he's sent the horses in front of him, he's got a duty to make sure it's safe going forward, and he didn't. So arguably, but I certainly get that's tenuous and maybe creative, but I don't think we have to say we got 1 of 3 options. 1 is certainly incorrect, 1 is maybe, and 1 is correct. We don't have to sit there and say, well, we went the incorrect avenue. I think that's for the trial court, for the judge to make that decision.
Can your colleague on the other side started with the Dalbert question. Do you want to give a brief response to that?
We stand by our brief, but I think Judge Whitney got it right. He's done many, many, many trials. I think he got it right. We stipulated to the expertise of both our experts. They actually didn't call their expert. I noticed they also cite in their brief to this court that these two OSHA regulations don't apply, but yet their own expert, which was submitted to this court in the joint appendix, agreed that those very same regulations did apply. So I think that's kind of bizarre. But I think Judge Whitney, we stipulated to the expertise, and then he says, here's why I have the expertise. It's, I was the president of safety globally or something. I've been in thousands of these things, and here's how I know, and here's the basis, and here's why they apply. I think Judge Whitney absolutely discharged his gatekeeping function when he heard all that evidence and say, yes, you have the expertise, and this does apply. Just because they now say, and disagree with their own expert, that it doesn't apply, that doesn't mean Judge Whitney didn't do his job at all. I think Judge Whitney did a fantastic job on that.
Bracketing for a moment whether this is adequately preserved. What is your argument for why Rusty and Campbell Cox could be held liable on a last clear chance theory? As I understand it, they weren't present when the injury happened, and they're not general partners of the partnership, and so they're not personally liable for anything that the partnership is liable for. So what is the theory for why they're liable on a last clear chance theory?
As you pointed out at the beginning of your question, we believe they've waived that argument, both twofold. One, it wasn't properly before the trial court.
Your argument on that. Let's just say we got past that.
I've espoused my theory on Mr. Rusty Cox using the unfettered ass analogy. I think it would also maybe apply to Campbell Cox, but it's weak. I mean, I'm not going to stand here and tell you it's not. It's weak, and I think, had we had that opportunity at trial court, we could have fleshed that out. Or the jury could have said, yes, yes, no, no on those.
I should know the answer to this, but as a matter of North Carolina law, are all of the defendants jointly and severally liable in the judgment?
At this point, yes. Yes. And if you don't have any other further questions, I'd like to save my remaining time as the cross appellant for reply.
Thank you, counsel.
If that's permitted. Thank you.
It will be. Mr. Robb, we're happy to hear from you. Am I saying that right? Is it Mr. Robb?
It is Rob, yes, thank you. Judge Richardson, you asked the question, what is the best evidence that other people in the bin knew that Robbie Plyler was in peril? And the answer to that is there wasn't any. None whatsoever. No evidence from which any reasonable jury could infer that anybody else in the bin was aware that Robbie Plyler had opened the steel doors that covered the sumps, that Robbie Plyler said he didn't know that the bars had been cut out, and that Robbie Plyler was unaware that he had fully opened those steel doors, and that on this occasion, Robbie Plyler, the safest man on the farm, wasn't paying attention to what he was doing or where he was stepping. Your Honor pointed to the evidence that all the testimony at trial was that Mr. Plyler was a good employee and a safe man, and in fact, that day, according to Mr. Plyler, when Rusty Cox called him, he said, I've got some boys in a grain bin. You're the safetiest man on the farm. I want you to go up there and keep those boys safe. There's no evidence that anybody in the bin should have surmised that Mr. Plyler was unaware of what he was doing. Now,
What do you do with your colleague says, listen, he, great farmer, all these sorts of things, but this wasn't what he did, right? This was not sort of the primary responsibilities that he had, and the idea of sending him up there to sort of generally supervise is one thing, but nobody would have thought that he was getting in the bin. And so when somebody sees him in the bin, they should have said, hey, you're not usually in the bins, and don't forget, or let me tell you that the bar is missing, and so if you put your foot in the hole, you're not going to have it.
well, Your Honor, even with the evidence in the light most favorable to the plaintiff, the bar was a non-issue. Plaintiff's own expert said removing the bar didn't matter. All that mattered.
That's not really true. So, all right, go past. That's actually not true, but go past that,
Well,
right? He says you could put a guard on it instead. You could add a guard on top.
That's
of it,
right. But he
nobody thinks they did that.
Well, I disagree,
Can you
Your
go
Honor.
back to the previous point? I understand you want to make that argument, but do you have an argument like why that doesn't work?
Well-
Other than the bar doesn't matter?
Yes, two things, Your Honor. So if Mr. Plyler was unaccustomed to grain bins, a reasonable man would not have walked up to the bin and opened the steel doors all the way without asking how much they were open, without telling anybody in the bin that he was
All right,
doing
so-
that.
So you've established contributory negligence. That's
And
helpful.
then, when
But-
Mr.
But why is
Plyler-
that relevant to the question?
Well,
That's contributory negligence. I'm asking about the last.
yes, but it relates to when he was helpless, Your Honor, and whether he was inattentive. Then when he climbs in the bin and is not looking where he was going, he's being inattentive. Under the Rule 480 analysis for inattentive plaintiff, the other people in the bin are only charged with acting for Mr. Plyler's safety if they know that he is in peril and have reason to believe that he is unaware of his peril and is not going to act for his own safety. And there was no evidence of that, Your Honor. I see that I'm out of time. Is there anything else you'd like me to address?
Thank you, counsel. We will come down and, sorry. You want to talk more, don't you? Come on. No. I'm happy for you to come back up. We're not used to having to cross appeals, but Judge Heitens helpfully points out that you got more to say.
I do, and, I don't, procedurally, it's a little unusual, so I don't know if I'm confined to keep my comments now to our cross appeal.
I'm not going
or-
to cut you off.
Okay. Well, I'll just respond briefly to what Mr. Robb just said when I think he stated the law about did the defendants, did the appellants know that Mr. Plyler was unaware of the bar out? That's not the law. The law in North Carolina from the Exum case that I've highlighted during this argument states, it is clear the court held, there must be proof that after the plaintiff had, by his own negligence, gotten into a position of helpless peril, parentheses, or into a position of peril to which he was inadvertent, the defendant discovered the plaintiff's helpless peril or inadvertence, or being under a duty to do so, should have, and thereafter the defendant, having the means and the time to avoid the injury, negligently failed to do so. It's what I said earlier. It's knew, should have known, or had a duty. And there's no question that they had a duty that under OSHA and under the standard of care that we submitted to the jury, they had a duty to ensure the safety of the employees going into the bin of an unguarded auger in conditions such that they were. It was very difficult. Second is they should have known, is that you had men in there that knew the bar was cut out and they knew that other people didn't know. To quote Mr. Campbell Cox, he says that they didn't need to know. Talking about Mr. Leos and Mr. Gonzalez says they didn't need to know. They're paid to go in and sweep. The men that are every day, that are most doing that job, that are boots on the ground for that job, say that they didn't need to know. It's on a need-to-know basis. And that's unacceptable for an employer when you have an unguarded auger to discharge that duty. And I think that's what the jury found and said, you should have known. You should have told those people, and you had a duty. And I think the jury is proper to do that. And the evidence certainly supports, assuming this was all properly before the court, the evidence certainly supports the jury's verdict, and we ask that you affirm the trial court.
Thank you, counsel. We will now adjourn court for the day, Madam Clerk. We'll come down and